Having that in mind, and I'll proceed to my second pledge, which is that the military camp was lawfully targeted.
Agent, before you proceed, you mentioned that there is a customary law concerning your argument, where we can see the state practice and the opinion juris of this customary law.
According to the ICRC studies, the general principles of international law are considered to be customary, and these principles and these studies from ICRC were recognized several times by the ICJ.
But my question concerns with the two elements from the customary law, where we can find state practice, where we can see a lot of states respecting this norm, and also how we can prove the opinion juris here. I'm aware of the ICRC studies, but I want to know the two elements of the customary law that you mentioned.
We reaffirm that these principles were already mentioned in several decisions by this court, and the ICJ that recognized the distinction in proportionality, as for example, in the nuclear weapons advisory opinion, and this is what we submit.
Okay, you may proceed, Agent.
Agent, if I may add a question. Now, you just mentioned the ICRC as a reference for my brother judge's question. And the same ICRC says that there is a customary norm regarding the protection of the environment in the context of military activities. So how would your submission of the ICRC's relevance is compatible with your argument that there is no customary norm binding your state in this matter?
Thank you for your question, Your Excellency. As I will further explain, according to Rule 43 of customary humanitarian law confirmed by the Committee of the Red Cross, the environment only shall be protected against any attack if they do not contain a military objective. And this rule is applicable to non-international conflicts, which mentions, is the only norm that explicitly mentions environmental protection, and it actually covers the responsibility of NHER. And this, the ICIC has big relevance since all parties to the Geneva Conventions ratified that the Red Cross owns a special position in the field of international humanitarian law. Shall I proceed?
You may proceed.
Thank you. In my second argument, I would say that military camp was lawfully targeted, and that I say because despite being a Ramsar site, the man-made wetland complex is not unconditionally protected from any attack, especially if it shelters a military objective, as I aforementioned. And thus, the camp located in the wetland was lawfully targeted. And according to the aforementioned Rule 43 of customary humanitarian law confirmed by the Committee of the Red Cross, the environment only shall be protected against any attack if they do not contain a military objective. And its Rule 8 also defines the customary concept of military objects as those that make an effective contribution to military action and whose neutralization offers a military advantage. In this way, the man-made wetland complex was a definite military objective, as this was the place from where the armed group were using the camp for military purposes. And it was yes,
Agent, can you provide this court with a legal case from this court or any other tribunal that supports your definition of military objective or military target?
Yes, Your Honor, thank you for your question. I'm not able to give this information right now, but later on I can deliver this information. Can I proceed? In this way, it was recognized that a successful operation against the military camp set in man-made wetland complex will significantly shorten the path to peace, which in fact did. And this further highlights the precautionary measures taken by the applicant when designing its military operation. Besides the understanding that no civilians live nearby, Enher also used drones to strike only to the camp and secure the success of that singular attempt. The weapon used was also carefully chosen, Your Honors. The M119 howitzers are explosive bombs, not considered incendiary weapons according to Article 1, Point B of Protocol 3 of the Convention on Conventional Weapons, the CCW. And thus, Enher duly respected the rule of distinction, which allows attack when the target is a military object, and the operation also occurred in full compliance with the principle of proportionality. The applicant was diligent enough in making a proportionality assessment and only launched the operation when it was confirmed that the damage would have been proportional to the advantage. And it is proven by the outweighing interest of the measure taken by Enher, since the foreseeable damage of a precise attack against a singular and uninhabited area would be of much less relevance when compared to the further losses of innocent lives. This was confirmed by the assessment made with available information at the time. And this is not unknown by...
Agent, but before you proceed, I'm not sure because of your argument, because your attack caused a huge harm to the environment of that place. So why you are stating that you are respecting the principle of proportionality? Because there's a clear environmental harm here in this case.
Thank you for a question, Your Honor. Thus, even in wartime, a certain level of environmental damage is allowed. This is actually proven by the very existence of rules which prohibit greater levels of damage. And this is not unknown by international case law as established by the International Tribunal for Yugoslavia, for former Yugoslavia, in a NATO bombing case. More specifically, in its paragraph 19, it determines that if the target is sufficiently important, a greater degree of risk to the environment may be justified. Shall I proceed?
Yes, you may proceed.
I actually have an additional question, if I may, Brother Judge, and oral is for the applicant. You say that there was an assessment of proportionality. Now, who was responsible for making such assessment?
The military commandants of the operation and
So are you asking this court to consider that a unilateral assessment is enough so as to establish whether there was a breach of international law as serious as one concerning the protection of the environment?
Yes, Your Honor, because specifically in this case, the military necessity has to be recognized, because this rule has been established as a norm of customary international law applicable to all types of armed conflict, the military necessity, and it was emblematically used in the hostages trial at the Nuremberg Tribunal as enough to justify environmental damage. And in this case, a concept called the Rendulic rule emerged, according to which situations have to be judged as they appear to the military actors at the time. And this means that the subjective perspective of the commander at the time in the operation is what defines the military necessity. And this perspective is also endorsed by the ICTY in a NATO bombing case.
What about the jurisprudence of the International Court of Justice regarding necessity in general? What would be the requirements that the court established regarding necessity?
I can further elaborate on that answer, but as in the moment, this is what I submit. And
you may proceed, Agent.
Thank you, Your Honor. In this sense, even more, the prohibitions of widespread, long-term, and severe, all places a specific limit on the kind of environmental destruction that can be tolerated. And this fact alone presupposes that even the most protective agreements will accept a certain amount of harm to the environment. And even more, this rule exhibits overall vagueness and inconsistency, and is without an international consensus in its application. And furthermore, this rule specifically prohibits methods or means of warfare that are intended or may be expected to cause this type of damage, which was not the case. And this means that those rules prohibit a state from launching an attack, knowing exactly its risks. And thus, as my co-agent will further explain, it was impossible to accurately calculate the environmental risk of Enher's operation due to the respondent's mismanagement of the area. And having presented these allegations, I may proceed to my third argument, which is that Enher is sheltered by the principle of military necessity, and it is not liable under international environmental law. And this means...
Agent, I see that your time is up.
Okay, thank you for
thank you for your submissions.
Could I use a more 30 seconds to finish, or is it possible?
Yes, you may have 30 seconds, and we must make sure that the other team has an additional time, a proportional additional time as well.
Okay, thank you, Your Excellency. So to conclude my defense, the Federal States of Enher reiterates that Enher's actions are sheltered by military necessity. The prohibitions of widespread long-term and severe cannot apply to Enher, since the situation discussed is a non-international conflict, and that it was a proportional operation, and that the obligations of international environmental law does not apply in the circumstances of the case. I thank Your Excellencies for the appreciation, and I now finish my pledge and pass the floor to my co-agent.
Perfect timing regarding the additional time. Thank you, agent. The second oralist for the applicant may have the floor.
Thank you, Your Honor. May I begin? Okay. Good afternoon, Your Honorable Judges. May I please the court? I'm Marcela Naum, and I will now defend the second and third segments of arguments presented by the Federal States of Enher, which are: first, the damage caused to main wetland complex is not considered a wrongful act, and its consequences are not fully attributable to Enher. And second, wrongful breaches international law in the matter of the hotels project in the Scuto coastal wetland. If I may recall on what my colleague already established, the military response adopted by Enher were excused by insecurity and the danger that the armed group represented. Nevertheless, the respondent alleges that Enher did not follow its international obligations when addressing its target. This does not deserve it to prosper, since Enher was required by an imperative military necessity to act, which excludes the wrongful character in question. Moreover, the causal link between the attack and the damage has been broken because of the respondent's negligence. Since 2014, it has been failing its duties towards the Ramsar Convention, letting the main wetland complex suffer from an extended drought, which has changed its ecological character. Since Rongo did not follow its duties to communicate with the Ramsar Secretariat, Enher could not have expected the operation would spark a fire with those dimensions. Therefore, the damage caused to main wetland complex is not fully attributable to Enher. Enher was actually careful enough to use precise and non-incendiary weapons, but the fire was only ignited because of the drought condition, which could not be accounted for. Thus, the causal link between...
Agent, before you proceed, are you aware of the circumstances precluding wrongfulness under the responsibility of states under international law?
Yes, Your Honor, I understand what a wrongful act means, and I thank you for your question. Should I define what a wrongful act means for international?
No, the circumstances precluding wrongfulness. Like, for example, self-defense, for instance. Are you aware of all the situations precluding wrongfulness recognized by international law? And if so, one of them could be applicable here in this case?
Yes, actually, I can say that I'm aware of all the conditions to preclude wrongfulness, but I can say that the military necessity is a condition to excuse the wrongful character in an act.
Concerning the necessity, do you have any case law from the International Court of Justice recognizing the necessity as a circumstance precluding wrongfulness?
Yes, Your Honor, and I could say the NATO bombing case was a case that recognized these circumstances. So may I proceed?
Could you please tell me the facts of the NATO case and how this court decided in this case that you mentioned?
It occurred when Yugoslavia was bombed by the NATO, the organization of North American, by the NATO organization. But I'll assure that I assure that my colleague will elaborate more on this subject in our rebuttal.
No, but I would like to know the facts of this case, or how this court decided when this court judged this case, how this case can be related for your argument. I would like to know this point.
And this can relate to our argument because it's an emblematic case that has lapidated the international law, and I'll use in my submission as a paradigm, an emblem to discuss the environmental damage in non-armed. No, I'm sorry, Your Honor, in armed conflict. But I must reassure that we are discussing here a non-international armed conflict.
Okay, but before I proceed, when this case was judged by this court?
I'm sorry, Your Honor, I apologize. Actually, it was not decided by this court, but the ICTY.
Okay.
I'm sorry.
Okay.
May I proceed?
Yes, you may proceed.
Thank you. So as I was previously saying, I was discussing the compensation deriving from environmental law for environmental damage. Compensation deriving from environmental damage has been dealt by this court on Costa Rica against Nicaragua in certain activities by Nicaragua. And in that case, this court has said that in order to compensation to be granted, a causal link between the damage and a wrongful act by a state has to be demonstrated. In our case, one cannot find such causal link on the proportionality of the attack and the unexpected fire. Rongo's lack of will in preserving the area and at least fulfilling the duty of publishing information was the reason for the incidental and final damage. Therefore, the causal link has been broken. And more recently, in the judgment of February 2022, in the case armed activities on the territory of Congo, between Congo and Uganda, it was reinforced that compensation can be awarded only if there is a sufficient direct and certain causal nexus. Thus, the compensation pledged by the respondent may only be disregarded. So as my second argument...
Agent, are you saying that there's no causal link between the activities and the environmental harm in this case?
Yes,
No.
Agent, please elaborate more on this subject.
Yes, Your Honor, and I thank you for your question. Actually, what I'm saying is the causal link, the direct causal link can be seen in the situation because the drug condition, as it was stated in the case, in the factual case, it was the fire only was ignited because of the drug condition. It has been going on since 2014.
Can you point to this court where in the agreed facts there is that statement?
Yes, Your Honor, just a moment.
Because it seemed, at least from a first read, that the harm was aggravated by the drought conditions, but the fire was not initiated because of the drought conditions. And moreover, shouldn't your country be aware of those risks, of those increased risks, and take that into consideration before adopting the military activities it adopted?
Thank you, Your Honor, for the continuation of the question. In the case, you can see in paragraph 21 what we have submitted, and regarding our previously measures regarding the Aarhus Act, we submit that we had studied the area before, but we couldn't see factually see that the drought condition was in this situation. Brongo had obligation according to the Ramsar Convention to monitor the area and submit according to Ramsar Convention Article 3.2 to submit a report when the area had its ecological character changed. So therefore, since Brongo had not complied with its duty to inform the Ramsar Secretariat, we could not access the full information that was available to perform an exact and precise attack as the area demanded. We had only with the information we had available at the time, and we have done a really precise work in preparing an attack that was precise and meticulous. But since the conditions, it was not, we couldn't account for the drought condition. We could have not prepared to the drought, the severe drought condition that the main wetland complex faced.
Agent, I see that you have a few more minutes. Perhaps you could address the second issue of the problem.
Okay, I will now address the hotel project, the hotel project on the Scuto coastal area. So primarily sustain that since Brongo is still the Scuto coastal area is still a Ramsar site, the obligations under the Ramsar Convention are still applicable, because according to the draft articles on state succession, it's Article 2, which was the only one that has acceded as a customary international law. It was recognized by this court in the Gabikovo Navigimaros case. When an obligation is related to the use of a territory or to jurisdictions upon its use, the successor state is still bound by these obligations. The Ramsar Convention fits this definition because it has the purpose of preservation of wetlands. Hence, Brongo goes against international law for using its sovereignty allegations over Camp Key in order to neglect obligations of protecting the wetland. And even if the Scuto coastal wetland was not considered a Ramsar site, Brongo is still a signatory of the Ramsar Convention and recognizes the general duty to preserve wetlands. This is foreseen in Article 3.1, 4.1, and in this sense, Brongo is still bound to the duties under this Article 3.1, which equates to the obligation to institute a no-loss approach policy. This policy has two main ways to preserve wetlands. First, by the selection of a non-damage location for a development project, and two, by opting for a no project when the options of the damage is assessed as being too high. This resolution 11.9 reaffirms such commitment in paragraph 14, but the respondent, however, chooses not to comply with such obligations, putting in risk the Scuto coastal wetland. Also, the EIA conducted unilaterally by Brongo goes against several international conventions such as CBD, the Ramsar Convention, and the Inter-American Convention, as the biological diversity of Aarhus is will be affected if the hotel enterprise takes place. And also, the Brongo doesn't even comply with its own environment impact assessment, because the facts confirm that the permit will allow the use of spotlights in several places of the hotel. However, Brongo has only determined the use of shade screens in one part of the hotel. Since my time is coming to an end, I thank you, your honors, for your time, and I pass the floor. Thank you.
Thank you, Agent. The first oralist for the respondent may have the floor.
Agent, before you proceed, would you like the extra 30 seconds as instructed by Mr. President to be added to you or to your colleague up front?
To my colleague, please. Thank you. Good afternoon, Your Excellencies. Am I audible to everyone?
Yes.
Thank you. May it please the Honorable Court, my name is Gabriela Bellotti, and also on the panel is my co-agent, Carolina de Caldas Bezerra. We appeal on behalf of the respondent in the present matter, the Republic of Rongo. I will address this court for 15 minutes on the question of whether Rongo violated international environmental law with respect to the hotel complex project, as well as why UNHWR violated Rongo's sovereignty with its armed attack on the Menhe wetland complex. My co-agent will be furthering my submissions by addressing the question presented before the court regarding the violation of international environmental and humanitarian law by UNHWR's attack on the Menhe wetland. My speech will specifically address that first, Rongo did not violate the Inter-American Sea Turtle Convention, nor the Convention on Biological Diversity. Second, that Rongo complied with the principle of sustainable development. And finally, that UNHWR violated Rongo's sovereignty. Your Excellencies, to contextualize my submissions, if we may look at page 12 of the record, the Rongoan Ministry of Environment and Sustainable Development announced that it was granting a permit to the construction of a hotel complex within the skewed coastal wetland in Camp Key, with the objective, of course, of increasing ecotourism in the area, as well as promoting the development of the local community. Now we highlight.
Forgive me, Agent, you said page 12. Can you be more precise and indicate the paragraph?
I apologize, Your Excellency. I do not have the paragraph.
You may proceed.
It's towards the top of the page. We highlight that an environmental impact assessment was indeed conducted prior to the announcement, and observations were made in the permit as to only allow the constructions if measures were taken to block internal lights that may interfere with the Royal Ridley's nesting habitat. That said, Your Excellencies, the project perfectly complies with the Inter-American Sea Turtle Convention, as we'll see. Now, this convention has never prohibited human activities in the nesting areas of animals, but rather
Yes. Before you proceed, you mentioned environmental impact assessment. So
yes.
How this court established the standards for good environmental impact assessment in the Pope Mills case, judged by this court?
Yes, in the Pope Mills case, Your Excellency, although it is the specificities of an environmental impact assessment are up to national legislation, the EIA must follow some stages, namely screening for potential risks, also scoping those risks and going deeper into them, and then finally reaching the step of assessment and evaluation of those risks to see to what extent the risk will potentially cause the harm. Further, the actual EIA report, including an environmental management plan, as well as decision-making finally, and after the project is completed, also monitoring.
Okay, you may proceed.
That said, Your Excellencies, Rongo complied with not only this provision in the Pope Mills case, but also a similar provision in the Convention on Biological Diversity's Article 4 that provides guidelines for impact assessment and minimizing adverse impacts, notably from adopting procedures requiring environmental impact assessments of projects that are likely to have adverse significant effects on biological diversity. Further, the IAC in its Annex 2, Item 2, states that parties should adopt measures to protect and conserve sea turtle habitats within its territory and managing, when necessary, of course, the use of artificial lighting. Now, in parallel with that, Resolution number 11.9 of the Ramsar Convention proposes a framework and guidelines for avoiding, mitigating, and compensating for wetland losses. And these include changes to the scale, design, location, management, and monitoring of the proposed activity, as well as restoration or rehabilitation of sites.
Agent, what's the legal nature of the resolution you're quoting?
So this resolution, however, is not binding to any of the states, but we must highlight that resolutions, even though not binding, they merely represent an opinion that lawmakers want to emphasize. Nevertheless,
what kind of source are they in international law?
They are a secondary source according to the Article 38 of the ICJ statutes, and they they are made within the scope of an agreement or convention, and they overall embody the same commitments and values. Further, Article 31 of the Vienna Convention also states that the whole context of a treaty or convention must be considered. Therefore, the resolutions
which
also
Vienna Convention, agent? You mentioned
the Vienna Convention on the Law of Treaties of 1969,
okay.
Your Excellencies. I apologize.
Agent, if I may ask you an additional question on this point. Now, you mentioned resolution 11.9, and if I'm not mistaken, that resolution emphasizes that the very starting point for mitigation and compensation is the imperative to seek to avoid wetland losses or degradations in the first place. Now, I would ask, how did your country avoid wetland losses or degradation?
Yes, Your Excellency, Rongo did avoid it by conducting the EIA and adapting the permit to those observations. Further, according to the Sea Turtle Conservancy, a international nonprofit organization based on scientific evidence, a pervasive challenge throughout the Caribbean region where Rongo and Lanhur are located is light pollution at the beachfront, which can be defined as the introduction of artificially produced light into areas where it's neither needed or desired. Now, as the applicant said, Rongo will have spotlights in certain areas for security purposes. Now, fortunately, reducing light pollution is among one of the most manageable of conservation practices. So artificial lighting does not need to be completely eliminated if proper lighting management techniques are adopted. Artificial light only becomes a problem if the light or glow from the source can be seen from the beach during nesting and hatching seasons. Now, hotel and resort projects in its initial stages of development are encouraged to incorporate good lighting techniques into their buildings as the respondent's EIA submits. Now, the best practice is to prohibit lights near the nesting beach area and adopt turtle-friendly lighting, like low-pressure sodium lights. These kinds of lights are the least detrimental to sea turtles. Now, monochromatic in color, LPS have the longest wavelengths, which sea turtles do not detect as readily. Rongo also shows its concern with responsibility with the site by shielding the screens, which is actually the first step to mitigate harm to sea turtles. Shielding an open light source may reduce the amount of light directed onto the beach, and it significantly reduces hatching and disorientation of turtles. That said, Your Excellencies, Rongo's actions were appropriately taken to achieve not only the purpose of the Inter-American Sea Turtle Convention, but also complied with the CBD guidelines on impact assessment. Further, from my next submission, we highlight that the hotel complex project also complies with the principle of sustainable development.
Before you proceed, Agent, I'm still very concerned, especially with your state's obligations regarding Article 4 of the IAC. Article 4 says that your state must take appropriate and necessary measures for not only the protection and conservation, but also the recovery of sea turtle populations. Now, could you clarify how your state is achieving this end, or is it not?
Yes, Your Excellency, Rongo is going to achieve this purpose. But firstly, we highlight, as seen on paragraph 17 of the record in the Remsart listing, the skewed coastal wetland faces inappropriate agricultural practices, subsistence hunting, and overall exploitation of marine resources and other development pressures. Now, that said, with the added attention that from the construction of a hotel that is concerned with the environment and responsible traveling and mostly the local empowerment, there will be an increase of public awareness and also participation from government and non-government institutions.
I understand, but what about the sea population, the turtle population?
Your Excellencies, neither the EIA or any other document has proven concrete harm to the sea turtle population. Now, for some context, I will highlight that in the construction of a road along the San Juan River case judged by the ICJ, the court concluded that Nicaragua had never proven that the construction of the road caused significant transboundary harm to Costa Rica. Therefore, it dismissed Nicaragua's claim on this point. Therefore, bringing it to our case, we do not have any consistent evidence that more harm than anticipated will take place, and even the potential harm anticipated will be appropriately mitigated by Rongo's mitigation measures. That said, Your Excellent. Yes?
Please, isn't permitting a hotel complex and marina near on a part of a turtle's nesting habitat inconsistent with the objective of the IAC?
Your Excellency, in fact, it is not inconsistent with the purpose. Once the IAC establishes in its Article 2 that it is necessary to take in the socioeconomic characteristics of the state in discussion. And that is so that middle-income developing countries like Rongo have room for development, both economically and socially. In fact, this is actually supported by the preamble of the CBD that recognizes that economic and social development, as well as poverty eradication, are the first and overriding priorities of these developing countries. Further, in Article 11 and 21 of the Johannesburg Declaration on Sustainable Development, and as well as the fifth principle of the Rio Declaration, they all recognized that states and all people must cooperate in the task of eradicating poverty as an indispensable requirement for sustainable development. And further, the project strongly recommended by REMSAR resolution number 11.7, as it makes wise use of the site and develops practices for sustainable tourism, poverty alleviation, and local empowerment, and most of all, wetland conservation. Now, to illustrate this, Your Excellencies, we highlight that in Brazil, there is a successful hotel complex project focused on ecotourism that has had a 17-year-long partnership with the Tamar Project, an NGO specialized in sea turtle protection. Now, according to the Tamar Project, their partnership began with the construction of the hotel with advice regarding lighting adaptation, the very object of the present matter. And it extends today into their current activities that are mostly related to public's participation. It is notable that over 100,000 guests were contemplated by such activities. This way, Your Excellencies, not only Rongo complied with Article 3.1 of the REMSAR Convention to protect wetlands as far as possible, but also it is on the path to develop a successful green hotel that will ultimately increase the protection of this wetland by giving it the attention it actually deserves. That said, Your Excellencies, moving on to my final submission. Now, while Rongo fully complied with its international rules and principles, who clearly violated them by launching an armed attack on Rongo's Manhit wetland complex, as my co-agent and I will soon demonstrate. Now, for some context, page 8 of the record states that on November 6, 2019, Anhur fired approximately 200 high explosive artillery rounds at Rongo's Manhit wetland complex that ended up burning 80,000 hectares of the peat swamp, destroying approximately 65% of the complex. That said, that attack was carried out in utter disregard to Rongo's sovereignty. The United Nations Charter establishes in its Article 2, Item 4, a prohibition on the use of force by member states. Moreover, we highlight that the wetland is a REMSAR site under the REMSAR Convention, which has the purpose to protect wetlands on a global scale, and more specifically with enhanced protection REMSAR sites. Now, to illustrate this, Your Excellencies, in certain activities carried out by Nicaragua versus Costa Rica, the court recognized that Nicaragua violated Costa Rica's territorial integrity with the occupation and use by its army of Costa Rican territory, and it was later decided that Costa Rica was owed compensation. Also, in the Democratic Republic of the Congo versus Uganda, the court rejected Uganda's claim of self-defense and stated that Uganda had violated the sovereignty and territorial integrity of the DRC. Now, I see that my time is coming to an end, Your Excellencies. Therefore, we can see that the attack on the Manhit wetland constituted a violation of state sovereignty once Anhur did not refrain from the use of force against Rongo, nor did it notify the state of its intentions, resulting in massive damage in the Manhit wetland. That said, Rongo's sovereignty was only one of the many violations of international law by Anhur, as my co-agent will now demonstrate. So unless the court has any further questions, that concludes my submission on behalf of the Republic of Rongo. I thank the court for its indulgence and may it please the honorable court. Thank you.
Thank you. The second oralist for the respondent may have the floor.
Thank you. Are your excellencies hearing me well?
Yes.
Good. Mr. President, your excellencies, may it please the court. My name is Carolina de Caldas Bezerra, representing the respondent, Republic of Rongo. I will speak for 15 minutes regarding the following. First, UNHCR violated international humanitarian law as the Manhi wetland complex was not a legitimate military target. Second, UNHCR failed its duty to cooperate towards environmental protection. Third, and finally, UNHCR must compensate Rongo. Your honors, my first submission will state the violation of international humanitarian law, since the case at hand is consistent with its application. During armed conflict, the international humanitarian law also seeks to conserve the natural environment, which is essential to human life. Additionally, the Manhi wetland complex did not characterize a military objective. According to the International Committee of Red Cross, the environment is covered by general provisions regarding warfare. Unless this has been developed into a military objective, the environment is civilian in character and cannot be attacked. As it is indicated, yes, Your Honor.
Before you proceed, can we apply here in this case Article 55 of Additional Protocol 1 of the Geneva Conventions?
Your Excellency, if you could, the additional protocol?
Additional Protocol 1.
Okay, Your Honor, neither UNHCR or Rongo, it's binding to these conventions, as only the Geneva Conventions of 1949 is see as customary law. I don't think that this additional protocol applies to the case at hand.
Okay,
and moreover,
so you will base your argument on customary law?
Yes.
Okay.
This principle of military objective is seen in the guidelines on the protection of the natural environment in times of armed conflict, and it is seen as customary law. In that sense, military targets are defined by Rule 8 of International Humanitarian Law as objects that by nature, location, purpose, or use make an effective contribution to military action and whose total or partial destruction or capture or neutralization offers a definitive military advantage. Thus,
Agent,
yes, Your Honor?
I believe that the guidelines you just quoted from the ICRC also state that even though there's a customary norm, it may not apply to all states. For instance, the United States has been a persistent objector to the emergence of this norm. So why should this court then consider that this customary norm is present and applicable to the parties before the court in this case?
Your Honor, you were mentioned the military objective or the civilian in character, or both? Your Honor?
Both.
Okay, thank you. Your Honor, the ICRC stated that this common sense of military objectives and natural and environment as a civilian in character is seen as customary law by almost every state that applies the warfare guidelines. And also it is stated in all Geneva Conventions, the mention of the military objectives and civilian in character. And Rongo has demonstrated in the diplomatic note stated in the record that considers the environment as civilian in character. In that sense, thus the Manhi wetland complex was not a military target. The environment should have been protected and by no means attacked. Your Excellencies, it is very clear that by attacking the Manhi wetlands, UNHCR has violated international humanitarian law. The violations are twofold. Firstly, in regard to the lack of military legitimacy and proportionality of the attack. And secondly, in relation to UNHCR's duty as a member of the Ramsar Convention to protect all wetlands.
Agent, before you proceed, allow me to go back to the previous point. Now, just to clarify, it seems that Rongo designated the Manhi wetland complex as a Ramsar site. It also relocated the people who live there. So after that relocation, is it still, or could it still be considered of a civilian character?
Yes, Your Honor, because the environment in this case was not a military objective. The swamp area did not characterize any military advantage to the group. They were located in the Manhu Wetland Complex just because it was the border. But if they were located in any other place within the border of Anhur and Rongo, the results would have been the same. The destruction of the wetland did not characterize a military objective to military advantage to the group. And that's why in this case at hand, the environment is considered civilian in character. In that sense, the ICJ has already expressed an opinion on the legality of the threat or use of nuclear weapons, and I quote, "States must take environmental considerations into account when assessing what is necessary and proportionate in the pursuit of legitimate military objectives. Respect for the environment is one of the elements that go into assessing whether an action is in conformity with the principles of necessity and proportionality." In that sense, a plea of necessity does not cover conduct regulated by a primary rule, Article 2.4 of the Charter in that case. It follows, therefore, that it does not cover an assertion of military necessity that is subject to regulations in the substantive provisions in the law of the armed conflict. Your Honors, Anhur's attack on the Manhi wetlands is neither the result of imperative military necessity, nor it is proportionate. It is an imperative, for it hasn't been sufficiently demonstrated by Anhur that there were an urgent need for the said attack, or that there were other feasible and satisfactory strategies per se more proportionate and less harmful to the environment and to Rongo's territory.
Agent, before you proceed, you mentioned and you reinforced the principle of proportionality on your argument. Is there any criteria established by this court concerning the principle of proportionality? I mean, what we can see as a proportional attack? If there are any topics that all countries must obey to be considered a proportional attack?
Your Honor, I don't have quite the answer to your question, but I can explain that the case we can see that is not proportionate because the Anhur's attack burned 65% of the hectares of the Manhu wetland complex and burned 80,000 of hectares, while the attack on the Anhur's territory did not cause such damage.
So, Agent, if that action was not necessary to protect the applicants' territory and population, then what would be the alternative in your understanding? What do you think that the applicant must have implemented in alternative to the attacks that it implemented?
Your Honor, Anhur could have asked for cooperation for the Security Council as established in Chapter 7 of the UN Charter, as the Security Council could act in that case. Anhur had communicated Rongo about the dangers of the paramilitary group, and with the cooperation principle combined, and have prepared a action control to prevent such damages. And also with the cooperation of Rongo, Anhur could have properly judged the paramilitary group, seeking the internationally recognized principle of due process of law. And the information that a proportionality analysis wasn't conducted isn't enough to properly demonstrate that the means chosen for the attack were in fact proportionate, especially in facing the results that would take like hundreds of years for the Manhi wetland complex to properly rehabilitate itself. That being so, Anhur's actions were conducted in complete disregard to the environment, as well as in dissonance of the duty of proportionality. In that
Agent,
sense,
should the applicant still try to communicate with the respondent if it believes that the respondent is somehow supporting the paramilitary activities at hand?
Your Honor, as stated in the clarifications A10, Rongo knew about the presence of the paramilitary group, but there is no other facts that Rongo knew about the attacks and knew about the harmful that the paramilitary group could apply to Anhur, and that's.
So your country was aware of a paramilitary activity and yet it did nothing to stop it. So that would authorize the applicant to adopt necessary and proportionate measures, wouldn't it?
No, Your Honor. Rongo knew about the presence of a group, but did not knew about the activities that the paramilitary group was planning on doing to Unhurs, and did not know also the characteristics of the group, just knew that a group was in presence of the Manhu wetland complex. And in that sense, even if you consider Unhur's proportionality analysis pointed to no excessive destruction, the fact that that said destruction wasn't foreseen does not absolve the warlike state of its duty to take effective precautions against environmental damages, which, as pointed before, was non-existent in Unhur's part. Above all that information, it is important to state that Unhur's attack violates the UN Charter. Its Article 2.4 strictly prohibits the use of force by its member states. However, states are exceptionally allowed to use force in order to defend themselves if they come under armed attack. Additionally, Article 51 allows states to use force as a last resort to protect their integrity, but the right has a limit. Measures taken by the defendant states must be reported to the Security Council. Moreover, once the Council has decided to act, the defendant states must cease the measures taken in response to the armed attack. Therefore, Unhur breached Article 51 from the Charter when act without the Security Council's consent and attacked Rongo's territory. Even after the September... Yes,
Agent, forgive me for interrupting again, but this is a very interesting point. So you're saying that the applicant must have consulted with the Security Council before taking action. I understand that argument. Now, could you provide us with any example of another country that acted in the same manner? Because I'm quite worried that if we set this as a precedent, maybe the states won't have enough time to act in urgent circumstances, since the Security Council sometimes takes a lot of time to review each emergency that's presented before it.
Your Honor, I understand your question, and I would like to highlight that Unhur wasn't in a state of necessity because it didn't fulfill the Gapsikovo-Nagimaru's conditions. The state was not in an imminent peril, as the attack of the paramilitary group was just happened once, and it was not in that proportion that Unhur attacked back the former attack. And also, the Gapsikovo-Nagimaru's conditions stated that the interest of the state would have been threatened by a grave and imminent peril, and the act must have been by only means of safeguarding that interest. And as I already mentioned in my speech, Unhur had another options to stop the attack and stop the actions of the paramilitary group. And fourth, this act must not have been seriously impaired an essential interest of the states toward which the obligation existed, in that case, the essential interest of Rongo. And now, even after the September 11, the court maintained its understanding that self-defense could only be invoked in response to an armed attack by a state against another state. And that we can see in the advisory opinion of the legal consequences on the construction of a wall in occupied Palestinian territory. Unhur's actions also violate the duty to prevent transboundary harm. According to Article 3 from the CBD, states have the responsibility to ensure that activities within the jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. This duty is also foreseen in the Ramsar Convention in Article 4, the Stockholm Declaration, and Rio Declaration principles. Now, the scenario is clear.
Is it custom or is it the treaty norm?
In that case, the states are binded by the CBD, but also there is
I mean the duty to avoid transboundary harm.
Yes,
are you presenting it as custom or as treaty obligation?
As treaty obligations by the CBD. This scenario of transboundary harm, it is clear in several decisions of the ICJ, especially the Pulp Mills case, in which the control of the state's action in order to prevent environmental damage was discussed. And in that line of reasoning, Judge Denoke declared in the judgment on construction of a road along the San Juan River that equal sovereignty does not mean that one state can ignore a potential impact of an action of another state. In the present case, Unhur fired high explosive artillery rounds at the camp located in the Manhill wetland. Unhur's artillery rounds sparkled a fire that burned hectares of the swamp in the Manhill wetland complex, resulting in great losses. These lands are known for being the house of numerous animals besides supporting a variety of trees. A parallel between the pulp mill's case and the present matter can easily be drawn. Unhur's actions harmed Hongo's environment without his awareness, just as Uruguay authorized the construction of pulp mills without Argentina's consent. Pursuant to the consequences that arose from the fire caused in the Manhill wetland complex, the lack of recognition or accountability and consideration regarding the natural environment, it is clear that Unhur violated the duty to prevent transboundary harm. To start I see that my time is coming to an end. I will sum up my arguments. In the case of compensation, we refer to our written memorials and also about the cooperation towards environmental protection. During a wrap-up, Unhur's action harmed Rongo's territory, causing transboundary harm, and Unhur's action also violated international humanitarian law. If the court does not need my assistance, I will finish my submissions. Thank you.
Thank you, Agent. If the agent for the applicant wishes to present its rebuttal, she may have the floor.
Thank you, Your Excellency. Answering the questions previously made by the judges, the necessity has been recognized by the ICJ in the Nuclear Weapons Advisory Opinion, and NHER fulfills it because of the need to stop more attacks on the civilians and because it took measures to make sure the damage was proportionate, such as the type of weapon used, which was not incendiary, and the use of the drones to locate the camp and aim solely at it. And the military camp was a military object because it provided military advantage to the armed group. And furthermore, NHER did not conclude that it should have cooperated with a country which was aware of the presence of a paramilitary and non-peaceful group in its territory, setting up a camp in the area. Plus, the duty to give prior warning in war is only to warn civilians to leave the area, and NHER has not breached this. And the attack was proportionate to the advantage according to the assessment made using the information available at the time, not knowing the extreme condition of the drought, which changed the ecological character. And all of this complies with the ICRC Rule 44. And moreover, the UN Charter allows for the applicant to execute his duty of self-defense, and the Security Council resolutions 1368 and 1373 confirm that this right also extends to self-defense against non-state groups. NHER did not inform Rongo of the attack because the humanitarian duty of advance warning is established to allow civilians to get out of the area. The duty was never violated by the applicant as there was no civilians there, nor were attacked. Concerning the construction of the hotel, Rongo only determined the use of the shade screens in one part of the hotel. Therefore, they didn't even allow the EIA in its entirety. As it was stated by my co-agent, considering the worldwide percentage of species that reproduce at the site, the duty not to cause transboundary harm was breached. This duty is customary international law recognized in Pulp Mill's case and the Caulfield Channel cases. It is also mentioned in Article 3 of the CBD and Principle 21 of the Stockholm Conference. And moreover, the Ramsar Convention has recognized this type of construction to lead to problems such as high inflation and land speculation. Also, the hotel cannot be understood as sustainable, leading the long-term decline of biodiversity. And even if this court considers Rongo's project as ecotourism, we must take into account that massive growth of this industry may be harming wildlife through stress, disturbance of daily routines, and even increased transmission of disease, which is scientifically proven. And if Rongo wants to protect the Scoot coastal wetland, why is it so determined to remove it from the Ramsar list, which enhances the protection? Therefore, the federal states of NHER reiterates all of its initially defended claims and hopes that this court, with its usual parsimony, will fully recognize them. I now finish my submissions, and I thank the court for the appreciation.
Thank you, Reggie.
All right, the session is now adjourned. Judges will reconvene in a separate room to deliberate and give you feedback in a bit. Judges, you will
But,
see.
just one question, there will be no rebuttal? Okay.
Oh, there's no rebuttal in this
Okay.
competition. Yeah.
You will see an invitation pop up on your screens right now. Competidores fiquem à vontade para conversar, mas lembre-se sempre está sendo transmitido pelo YouTube. Olá, pessoal. Então, para quem está entrando aqui da outra equipe, podem ficar com a câmera desligada. Daqui a pouquinho a gente fala com vocês. E a gente vai dar prosseguimento aqui a essa rodada. Feedback.
Bom, pessoal, esse é um momento para a gente se conhecer, né? E também para dar o nosso feedback. Meu nome é Henrique Napoleão Alves, eu tive a honra de servir vocês aí como um dos juízes dessa rodada. Foi um prazer imenso. E antes de fazer os meus comentários e me apresentar um pouco melhor, eu já convido a minha amiga Tamires Loduca para se apresentar e, na sequência, o professor Ivonei Souza Trindade, eu fico para o final.
Boa tarde, pessoal. Bom, meu nome é Tamires Loduca, eu sou advogada, trabalho na área de ambiental e fiquei muito contente de poder assistir aqui e julgar os altos debates desse painel. Bom, vou passar a palavra para o professor Ivonei, para ele se apresentar também.
Olá, tudo bem? Todos vocês, bom, estão vivos depois dessa rodada, isso que importa, estão bem. Bom, eu quero me apresentar, eu sou Ivonei Souza Trindade, eu sou advogado aqui em Porto Alegre, e sou professor de Direito Internacional dos Direitos Humanos de uma instituição do Peru chamada Aparimum, Instituto de Investigação e Debate em Direito. Então, para mim é um prazer enorme estar aqui com vocês, aí, junto com meu amigo Henrique, professora Tamires, quem eu conheci agora, prazer em conhecê-la também, e aos times, as 4 oradoras que são as grandes estrelas aqui, né, dessa tarde, né? Então, parabéns a vocês aí pelo trabalho expendido até aqui, né? Então, eu gostei muito da rodada também, eu já posso dar meu feedback já, né, já, tranquilamente, tá? Então, eu gostei muito da rodada, deu para ver que vocês realmente pesquisaram, vocês realmente estão, assim, familiarizadas com a sistemática de multicortes. Eu só quero tecer alguns comentários aqui para, quando vocês forem participar de outras competições, outras rodadas, se avançar para a final, enfim, alguns comentários para vocês prestarem um pouquinho de atenção e levar isso em consideração, né? Então, primeiro ponto, a questão assim que é muito importante ter em mente é a questão da divisão do tempo da fala de vocês. Isso é muito importante para vocês conseguirem fazer uma boa defesa dos pontos que vocês levantaram, né? Então, por exemplo, vocês estão vendo que não vão estourar o tempo, não se desesperem, não inventem, eu preciso seguir à risca esse meu roteiro, então eu vou acelerar minha fala, e não façam isso, porque fica muito perceptível para quem está julgando que vocês estão muito presos ao roteiro e vocês estão acelerando a fala, os juízes não estão entendendo, e aí acaba ficando um ponto meio confuso, né, para nós que estamos avaliando aqui. Então, quando vocês verem que vocês não vão estourar, que isso é super comum, gente, isso aí, tem rodadas que vocês não têm um bombardeio de perguntas, que vocês, quando olham assim, nossa, tem 4 minutos para vocês ir para o próximo tempo. Então, esse é o momento de vocês tentarem improvisar, tentar cortar o que é supérfluo, o que não é tão importante. Então, cortem, adicionem, foquem no que interessa para fechar o discurso no tempo certo. Então, essa questão do gerenciamento de tempo é muito importante para vocês, porque às vezes se nota times que estão indo bem, estouram o tempo e naquele espaço de tempo que não souberem improvisar, se perdem, fecham o discurso de uma maneira completamente errada, os juízes não entendem, isso puxa a nota de vocês para baixo. Então, por isso é importante terem esse jogo de cintura, né? Bem importante. Um outro ponto importante, assim, que eu quero destacar, que é a questão de domínio de alguns fatos e casos que vocês citarem, e de conceitos também, isso é muito importante. Então, quando se fala em regras costumeiras, vocês vão saber de coração o que é um costume internacional, ou quando vão citar um caso, saber de coração também os detalhes daquele caso, onde ele foi julgado, por que ele foi julgado. Por exemplo, eu já vi rodadas disso no Jessa, no outro multicorte, por exemplo, de times em final não saber detalhes de caso que estão citando. Então, passa aquele vexame vergonhoso numa rodada final, né? Então, por isso é importante vocês dominarem bem as fontes de vocês que vocês estiverem utilizando, né? Então, isso é muito importante, esses conceitos. Então, isso é elementar, né? Isso é elementar. Outro ponto em relação a perguntas do juiz, por exemplo, quando um juiz ou uma juíza faz uma pergunta, e mesmo que não seja a ordem de que vocês estejam falando ali, e digamos, o juiz antecipou um ponto que seria explicado depois. Vocês não podem chegar e dizer, olha, eu vou responder depois na réplica, ou vou responder, ou o meu colega vai responder depois. Não, vocês precisam responder no momento. Por que isso? Por que deve ser respondido no momento que o juiz ou uma juíza pergunta para vocês? Porque o juiz e a juíza estão avaliando se vocês têm o jogo de cintura para poder lidar com situações adversas, e também um fator mais importante que eu julgo, que é a questão do trabalho em equipe, para saber se os oradores estão em sintonia. Então, por isso que é importante que quando um juiz ou uma juíza pergunta, vocês respondam, ainda que de uma maneira resumida. Vocês podem chegar e dizer, olha, resumidamente a resposta é essa, assim, 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 que será aprofundada posteriormente, ou pelo meu colega, se é um outro ponto, mas vocês precisam responder objetivamente a pergunta, mesmo que não seja ali no roteiro de vocês. E, por fim, uma questão de estilo, assim, que eu observei em alguns momentos, como aqui a simulação da SIG, né? Então, alguns momentos eu vi vocês falarem Your Honor, o correto é Your Excellency, só um detalhezinho formal aí de toque, caso vocês avancem para a final, enfim, ou para outros moot courts. Então é isso, gente, esse é o meu feedback, então eu quero dar meus parabéns a vocês, continuem participando de moot courts, e o moot court é um evento que mudou a minha vida, sei que meu amigo Henrique também foi participante, também mudou a vida dele, então é isso, gente. Continue participando. Qualquer coisa pós-rodada, estou à disposição para trocarmos ideias, materiais, que é isso que interessa o Mundo Corta, essas conexões que a gente faz, né? E o conhecimento que a gente constrói nessa caminhada. Né? Então é isso, gente. Parabéns e muito obrigado.
Doutora Tamires.
Bom, pessoal, eu reforço aqui as palavras do Dr. Ivonei. Eu achei que faltou um pouquinho de gestão de tempo. Isso é muito importante, não só nos multis, mas como para a vida. Assim, eu tenho certeza que vocês vão seguir uma carreira brilhante para a vida, né? E então a questão da gestão de tempo, também a questão da resposta às perguntas dos juízes. Eu entendo que alguns pontos poderiam ter sido melhor elucidados, não só trazendo aí o número de julgados, mas relacionando melhor os fatos que estão sendo julgados com a jurisprudência. Que mais? E eu acho que também precisa prestar atenção com a questão da leitura durante a rodada. Eu acho que a gente tem que ficar bem atento para ter, assim, um guia. A gente pode usar o guia, mas não ficar muito preso a ele a ponto de você ler durante a rodada. Mas é mais com relação a isso. Reitero os parabéns, continuem participando. E mais uma vez, foi muito legal participar aqui como julgadora dessa rodada de multicorte.
Bom, pessoal, olá de novo, né? Henrique Napoleão Alves, meu nome, eu sou advogado e professor, atualmente eu sirvo a Comissão Interamericana de Direitos Humanos como consultor e advogado, então eu estou falando com vocês de Washington, que está gelado, preferia 1000 vezes estar num evento presencial no Brasil, mas fazer o quê, né? Mas que bom que a gente pode, apesar da pandemia, né, estar aqui e compartilhar desse momento, né? Que antes de tudo, é uma celebração de valores importantes, que é muito legal que vocês, tão jovens, já estejam cultivando, né? E eu faço questão de destacar esses valores, né? Valores de amizade, de superação, de busca por novos conhecimentos. Isso é uma coisa muito séria e muito bonita, né? E eu queria convidar vocês a continuar participando dessa construção. Se não como competidoras e competidores aí em novas moot courts, por que não como juízes, né? E, claro, o lado de cá não é tão divertido quanto o daí, mas é a next best thing, né? Como dizem os anglófonos, né? E não é à toa que a maior parte das pessoas que participam da competição em qualquer nível continua voltando. É porque isso aqui é uma maravilha. Para mim, pessoalmente, eu tenho mais conhecimento em direito internacional e em direitos humanos, então é uma forma também excelente de todo ano eu aprender um pouquinho mais de direito ambiental, de direito internacional ambiental, tem esse lado também. Eu gostei muito da rodada, queria só apresentar só algumas considerações e sugestões. Muitas delas já foram até abordadas pelos meus colegas, e eu não vou especificar cada oradora, não, mas vou dizer assim, algumas coisas para os times. Eu gostei muito do time do Applicant, ter apresentado assim, um roadmap dos argumentos, né? Dizer logo no início, olha, a gente vai defender isso aqui com base nesses argumentos e depois caminhar nesse mapa, né, de argumentos. Também gostei do esforço de citar jurisprudência internacional, principalmente jurisprudência da corte. Também observei a mesma coisa no time do respondent e queria sugerir que vocês mantenham isso. Para juízes de moot courts, e já tem um bom tempo que a gente está julgando, né, assim, eu e o Ivonei, quase sempre a gente se encontra na Jessa, que é uma competição similar, e eu também já participei desse teste algumas vezes. Impressiona juízes, assim, vocês serem capazes de citar a jurisprudência, porque acaba sendo uma simulação nem tanto da corte como ela realmente funciona, mas muito mais uma espécie de Suprema Corte dos Estados Unidos, em que os juízes podem te interromper. E, enfim, por conta disso, a gente acaba valorizando muito os precedentes. É uma coisa meio de sistema de common law, assim, né? Embora a corte não seja exatamente isso, mas... Então, bom. Também a questão de responder as perguntas, assim, achei que ambas as equipes foram muito gentis e educadas, tiveram boa postura na hora de receber as perguntas, mesmo perguntas duras. É importante, no entanto, prestar bastante atenção qual que é o núcleo da pergunta e não fugir dele, né? E às vezes a gente é meio tentado, se a gente não tem uma resposta na mesma hora, a gente tenta dar uma escorregada para cá ou para lá, mas os juízes percebem. Então o ideal é tentar identificar, né? Também o ideal é não deixar de responder as perguntas, mas eu gostei que vocês do lado do applicant depois tiveram cuidado no rebuttal de endereçar as perguntas que não tinham sido respondidas. Qual que é o ideal? Responder as perguntas. Qual que é o segundo lugar ideal? Fazer o que vocês fizeram, corajosamente, tiveram cuidado, anotaram e corajosamente depois apresentaram as respostas, foram respostas interessantes. É uma boa postura. O problema da gestão do tempo, né? Ficou muito forte, assim, e aí é aquele cuidado. Os juízes querem fazer perguntas para fazer vocês brilharem, porque se a gente não fala nada, vocês não têm oportunidade de mostrar o tanto que vocês estudaram, né? Então a gente está assim, a gente está aqui para isso. E aí é para valorizar vocês. Só que às vezes, se vem muita pergunta, você pode acabar perdendo muito tempo. Você tem que ter essa maldade de, vou responder esse aqui mais rápido e já vou mover para o próximo ponto, sabe? Então, essa transição de um argumento ou de uma resposta para o próximo ponto, é muito legal ter isso, para que os juízes não roubem o seu tempo, ou para que você não fique com pouquíssimos minutos para a segunda parte da sua fala. Eu também achei que vocês leram um pouquinho demais. Ler é normal, todo mundo confere o material e tal, todo mundo faz isso, mas não pode ser em demasia. Ao citar os casos, né, é muito importante estar preparada para responder porque são perguntas comuns, os juízes perguntarem, você pode descrever sucintamente o caso? Tem que estar preparada para isso. Esse caso é sobre isso daqui. E por que ele é relevante? Por causa disso, disso e disso. Então, isso é bom estar ensaiadinho, assim. Qualquer fonte que vocês forem citar, está bem ensaiado antes. Enfim. E vários desses pontos que eu comentei para o applicant valem para o respondent também. Eu só acrescentaria no caso do respondent, assim, que eu também gostei do roadmap inicial. Eu achei interessante a estratégia de inverter os problemas. Eu achei isso interessante. Quando citar os fatos do caso, melhor citar parágrafo do que página. Você vai ajudar o juiz a conferir ali na hora. Então, é uma boa dica. E também, às vezes, não precisa tanto de bombardear o bench com um montão de casos. É legal, porque ambas as equipes mostraram, isso ficou evidente para a gente, assim, que ambas as equipes fizeram muita pesquisa. para estar aqui. Porque souberam citar um monte de fontes diferentes, isso é muito legal. Então, só tomou cuidado para, às vezes, não bombardear demais. Ou então, às vezes, você pode pegar assim, um dos casos e explicar por que ele é relevante, ao invés de só citar, e depois citar os outros. E falar, olha, no mesmo sentido, houve os outros julgamentos, tal, tal e tal. E para concluir, quando você está no respondent, você tem que, eu pelo menos vejo assim, você tem que ficar bem de olho no que o applicant levantou, né? Então, se o applicant, por exemplo, não está falando não falou sobre a Convenção Interamericana, se ele focou mais na Convenção de Ramsar, então é mais interessante você bater em Ramsar primeiro e, se sobrar tempo, apresentar seus outros argumentos. Então, ter essa maleabilidade de, durante a rodada, se adaptar sempre. Isso vale para o applicant quando for o respondent, né? Claro. Se você está no papel do respondent, se adaptar ali ao que o applicant logrou apresentar e o que ele focou mais. Gente, seria isso. Assim, eu também quase me esqueço, mas eu achei que o rebuttal foi interessante por dois motivos. Ele endereçou as perguntas que não tinham sido respondidas, algo que eu comentei antes. E a segunda coisa que eu gostei da escolha dos argumentos para o rebuttal. O rebuttal é para isso mesmo, é você pegar os argumentos que geraram mais controvérsia, ou que pareceram menos fortes, né? Os argumentos da parte contrária pareceram menos fortes. Eu acho que podia ter sido, no entanto, por outro lado, na forma de entregar, poderia ter sido talvez um pouco mais analítico, um pouco mais direta. Assim. No rebuttal a gente tem esses dois pontos aqui. É esse e ponto. Mas, mais uma vez, assim, é mais uma questão de forma do que de conteúdo. De conteúdo, gostei muito. Bom, o nosso amigo coordenador Rui Melo me disse que eu poderia dizer quem é o time que avança para a final dessa vez, ao final dessas considerações, né? Então, vou fazer isso. Eu sei que nem sempre é esse mesmo protocolo, né, nas competições, mas eu sei como é que vocês estão ansiosos para saber. Agora, a gente tira uma foto antes, Rui? Como é que é? Dá um print? A gente pode dar um print aqui para guardar essa recordação?
Podemos, então, já tirar a foto antes. Vamos lá, eu tiro aqui. Ok. Em 3, 2, 1. Perfeito, pessoal. Agora, então, Henrique, acabe com a ansiedade das pessoas.
Bom, mais uma vez, parabenizando demais ambos os times. Nessa oportunidade, o time do Respondent se saiu um pouco melhor e vai à final. Meus parabéns ao time vencedor, meus parabéns ao outro time. Vocês todas fizeram um bom trabalho e foi um prazerão mesmo. Rui, deixa eu também acrescentar uma coisa aqui, que é um convite para que a gente se conecte, todos nós aí, né? Estamos aí nas redes sociais, e um conselho para vocês aí, todas vocês, aproveitarem bastante o que essa competição também oferece em termos de comunidade, de contatos, né? De contatos profissionais, acadêmicos, né? A doutora Tamires, por exemplo, é advogado de um grande escritório, trabalha com direito ambiental, uma referência na área. O doutor Ivonei é simplesmente o autor do guia prático que todo mundo utiliza sobre enviar memoriais a amigos curi para a costeira americana. Então, considerem essa possibilidade aí de se conectar com seus novos amigos, tá certo? Felicidades e que todos os caminhos se abram aí para vocês, para os seus próximos passos. Parabéns.
Parabéns, pessoal. Obrigado a todos os juízes pela participação. Então, vamos fazer um breve intervalo para que os juízes possam beber água, fazer café, chá. Ele não está na Inglaterra, mas está no estrangeiro, talvez seja chá. Aí mostra, não sei o que mais estão tomando, Henrique. Então, vamos fazer uma pequena pausa e já vou organizando com as próximas equipes. Em 5 minutinhos, mais ou menos, voltamos. Tchau, pessoal.
Tchau, tchau.
Tchau, gente. Obrigada por tudo.
Tchau, gente.
Próximas equipes. Não precisa desligar não, Ivonei. Pode ficar
Não
aqui,
precisa.
só desligar a câmera e o microfone. Acho que desligaram,
Tá.
mas enfim.
Tá, né, que o pessoal saiu do Zoom aqui, aí eu fiquei...
Não, agora que eu vi que eles saíram, mas precisa não. É a mesma sala.
Tranquilo.
Até já.
Então tá, eu vou no banheiro, vou desligar a
Sim, sim,
câmera.
pode desligar a câmera aqui, o microfone, fica à vontade.
Obrigado. Daqui a uns 15, 20 minutos eu volto, mais ou menos?
Uns 5 minutinhos.
5, tá,
se
eu
possível. É,
só vou no banheiro ali. Obrigado.
sem pressa, obrigado. Equipes novas, vamos fazer uma conferência aqui de horários, de tempos, por favor. Então, nós temos na primeira equipe como applicant Marina e Kimberly nesta ordem, com 14 minutos cada uma, correto?
Correto.
E na sequência, nós temos Lívia e Ana Beatriz com 15 minutos cada.
Correto.
Desse modo, a primeira equipe terá 2 minutos de rebuttal. Ok, pessoal? Como vocês já sabem, o resultado vai sair imediatamente após a rodada.
Rui, posso ir
Henrique,
ao banheiro aqui
filhos.
também rapidinho? Tá no intervalo?
Fique à vontade. Assim que o professor Henrique entrar, a gente já pode dar início, tá certo, pessoal? Então fiquem por aí, perto.
Voltei.
Tranquilo. Não, estava referindo mais às equipes mesmo. Eu vi que você e a Tamiri já estão aqui. Mas apenas professor Henrique. Podem ligar suas câmeras para darmos início, então, à rodada. All right, so this court is now in session. The first oralist for the applicant will speak for 14 minutes. Mr. President, you may proceed. Allowing the oralist to begin.
May the first oralist for the applicant have the floor.
Good evening, Mr. President, Your Excellencies. May it please the court. My name is Marina Nascimento, and I have the honor to appear on behalf of the federal states of Anhor, the applicant in today's proceedings. For the next 14 minutes, the applicant will proceed to address the first issue regarding the man-made wetland complex. My co-agent, Kimberly Oliveira, will address the second issue concerning the hotel development in the skilled coastal wetland for 14 minutes. With your permission, we respectfully reserve 2 minutes for rebuttal. Your Excellencies, over the course of the next 14 minutes, I will be submitting the following 3 points. Firstly, Anhor's actions at the MPFF's camp is consistent with customary international law regarding armed conflicts and compliant with its obligations under treaties and conventions. Secondly, Rongo failed to submit an Article 3.2 report to inform the Ramsar Secretariat about the ecological change at the man-made wetland complex and thus violated international law. Thirdly, Anhor doesn't have to compensate Rongo for the damage caused in the man-made wetland complex. Beginning with the first topic, the applicant claims that it was exercising its right of self-defense. According to Article 51 of the Charter of the United Nations, self-defense is the inherent right of a state to use force in response to an armed attack. The attack made by MPFF was unlawful. Anhor was victim to the launched attacks by the MPFF from the man-made wetland complex, which not only damaged 2 residential buildings, 1 government building, but also murdered several Anhori citizens. And customary international law lays out the responsibilities of states and non-state armed groups during armed conflict.
Agent, before you proceed, you mentioned that you are using Article 51 of UN Charter, if I'm mistaken, right?
Yes.
For collective self-defense. Okay, but if I am mistaken, as this court interpreted in some case law here, this Article 51 requires some specific points to be observed, like, for example, respect of proportionality, respect of necessity, and also this Article 51 must have the action from the United Nations Security Council. So why are you still using this Article 51 for your argument, agent?
Yes, Your Excellency, you are correct. Article 51 does have some requirements, and the applicant submits that we fulfilled all of them. So regarding the principles of necessity, proportionality, Anhor had a temporal necessity to stop the rebel group from committing further attacks and killing more Anhori citizens. The Anhor military had already tried to quell disturbances from the paramilitary group before in a non-violent way, but after the attack, the artillery round was the last resort. And still, the artillery use did not exceed the required to achieve the objective, since the commander conducted a proportionality analysis and determined that the anticipated death or destruction was not excessive to the concrete and direct military advantage. And also regarding the Security Council, when it is a self-defense, the state does not have to report immediately to the Security Council because it regards an immediate action.
Agent, could you provide this court with an example in which it was deemed legitimate a similar action without consultation with the Security Council?
I'm sorry, Your Excellency, can you repeat your question?
Can you provide this court with an example of a similar attack being conducted without previous consultation with the Security Council and still being rendered legitimate?
Your Excellency, we have a few cases from the ICJ that shows us similar activities. We do not have a very similar case to present, but in the case of the Islamic Republic of Iran versus United States of America, this court decided in its paragraph 64 and 72 that the burden of proof of the fact of showing the existence of such attack rested on the state, which justified its own use of force as self-defense. So this reason, there's also a reasonable point of view that the lawful self-defense is restricted to the response to the armed attack. So in this sense, Anwar's attack was legitimate as self-defense because of its response.
Agent, before you proceed, you mentioned a case from the ICJ, but concerning this case that you mentioned, could you please tell me these facts concerning Iran versus United States, and if the facts also relates with harm to environmental as your country did to the respondents?
Can you repeat your question, Your Excellency? I'm sorry,
Yes.
my headphones stopped working. I'm not listening very well. I'm really sorry.
Okay, no problem. So you mentioned a case from this court, the Iran versus United States.
Yes.
So I would like to know if you are aware of the facts of this case that you just mentioned, and if this case that you mentioned deals also with harms to environmental, as we are dealing here in this present case.
Yes, Your Excellency. So this case also regards environmental damage. This case, it happened in 1992 when the Islamic Republic of Iran filed to the court instituting the proceedings against the United States with respect to the destruction of Iranian oil platforms. So this case is also recognized as the oil platforms. In October in 1987 and April 1988, the three offshore oil production complexes owned and operated for commercial purposes the National Iran Oil Company, and constitute a fundamental breach of various provisions of the Treaty of Amity and of international law. And in this sense, since
Agent, forgive me for interrupting, but
Yes,
I'm very concerned with whether this court should apply this doctrine to a paramilitary group.
Yes,
is there a relevant difference between self-defense against a state force and against a non-state actor?
Yes, Your Excellency, there is a difference. And the difference constitutes especially regarding being an international armed conflict or being considered a non-international armed conflict. The applicant claims that this is a non-international armed conflict since the attack was between a state, Anwar, and the MPFF paramilitary group. So in this sense, since Rongo did not violate Rongo's sovereignty because Rongo knew the MPFF had established a camp in the Manhit wetland complex. And since under the law of interstate force that says that if a state is unable to stop an armed attack against another state launched from its territory, we can say that Rongo was unable to stop this armed attack, and therefore Anwar did not violate Rongo's sovereignty. Besides,
Agent, can you point to this court where in the agreed facts there is information that the respondent was aware of the imminent attacks?
Your Excellency, I will not be able to point exactly the paragraph. If I may, I will bring it to you in the rebuttal.
Yes, you may. Please proceed.
So regarding, regarding about the MPFF, besides, according to the report of the Human Rights Council, the respondent also had the duty to ensure, as far as possible, public order and safety regarding the MPFF attack, and therefore they violated international law. Moreover, Anwar complied with its obligations under the World Heritage Convention. Article 6, paragraph 3 of this convention requires states not to take any deliberate measures which might damage directly or indirectly the cultural and natural heritage situated on the territory of other states parties to this convention.
Agent, before you proceed, this site where occurred the attack was inscribed to World Heritage List or was just a candidate for the World Heritage List?
Yes, Your Excellency. The World Heritage, the Ramsar site, Man-Made Wetland Complex, they submitted, they actually failed. So they're not a World Heritage site, but according to the same convention, all wetlands, they should be considered a natural site, a natural heritage, and therefore the applicant submits that it can be considered because the environment is very important to the international community.
In which part of this convention it's prescribed this rule that all wetland sites are also World Heritage, recognized by UNESCO?
It's Article 2. It states not only about wetlands, but also about other environment. So this article, it does not impose strict liability because in accordance with customary rules of trade interpretation, judged by this court actually in its arbitral award of 31 July of 1989, the Guinea-Bissau versus Senegal, this obligation involves a fault-based standard. It does not impose strict liability. And therefore, UNHWR complied with Article 6.3 as it exercised due diligence concerning the attack on this site. And UNHWR also took the environment into account before making the attack because a proportionality analysis was conducted before the attack on the Man-Made Wetland Complex. As it will be further discussed, UNHWR did not know about the droughts in the site at the time of the analysis, and ultimately the damage caused only happened because of the unlawfully unreported droughts that endured for 5 years. These factors indicate that UNHWR did all it could to prevent the damage to the site. So in this sense, yes, Your Excellency?
Can you present a case from this court or any other court in which a unilateral assessment of proportionality was deemed sufficient?
Can you repeat your question? So
you're justifying your state's actions on a self-assessment of proportionality.
Yes,
now,
yes.
Is there any case law supporting that claim that a self-assessment of proportionality, a unilateral one, would be enough?
Your Excellency, the attack by the MPFF, it was imminent. So the criterion of imminence correlates with the Caroline formula from 1842, in accordance to which the self-defense can only be exercised in the situations where the need to respond in instant. And this Carolina formula was tested in the 19th century, but it was reaffirmed in the Nuremberg Tribunal after the World War II.
I understand your argument, but my question was a bit different. Now, I wanted to know if a self-assessment of proportionality is enough. If any international tribunal has ever decided in this direction.
Yes, Your Excellency, we submit that yes, the International Court of Justice made references to this principle that I've just mentioned in such cases such as the Nicaragua versus United States or the Republic of Iran versus United States of America. Moving on now to my next point, the article should have been submitted by Rungo because since the droughts were due to climate change and adversely affected the ecological character of the Man-Made Wetland Complex, the respondent had the obligation under this article to notify the Ramsar Secretariat. And now, moving on to my next point, UNHWR doesn't have to compensate Rungo for the damage caused in the Man-Made Wetland Complex. This court in the Nicaragua versus Costa Rica inferred that in order to own the responsibilities and obligations concerning the boundary harm, first must be conducted. I'm sorry, I said that my time is over. Can you concede me 30 seconds to finish my argument?
Yes, you have 30 seconds.
Thank you, Your Excellency. So in this case, Nicaragua did not have the obligation to compensate for any damage once its actions were not accounted for it. So consequently, once the saline-emetic wetland complex did not have the potential to cause the alleged damage, UNHWR is not obligated to compensate for it. If I can be of no further assistance to the court, this would conclude my submission. Thank you, Your Excellencies.
Thank you. The second oral is for the applicant. May have the floor.
Thank you, Mr. President, Your Excellencies. My name is Kimberly Oliveira, and as stated by my co-agent, I will be guiding this honorable court through the second issue of whether the actions of RONGO with respect to the proposed hotel development in the skilled coastal wetland violate international law. Your Excellencies, over the course of the next 14 minutes, I will be submitting the following 3 points. Firstly, that the skilled coastal wetland is a Ramsar site and therefore protected under the provisions of the Ramsar Convention. Secondly, that the site is also under the protection of other international instruments which are binding upon the state of RONGO. And thirdly, that the economic rights of the local population cannot suppress the rights of the environment. Beginning with my first topic, the applicant claims that the construction of the proposed hotel complex constitutes a violation of international law and especially of the Ramsar Convention, as it indicates the respondent's failure to perform its positive obligations in relation to a global environmental concern. Article 3.1 of the Ramsar Convention expressly determines that states parties must promote the conservation of the wetlands included in its list. Moreover, Article 4 of the same convention specifies the promotion of the conservation shall be done through the establishment of nature reserves on said wetlands. As per Resolution 11.9, not only should states prevent negative impacts to wetland areas, but also mitigate unavoidable impacts and compensate or offset any remaining impact.
Agent, one question. Does Article 3.1 applies to both facts within a territory or outside a territory of a state? How territoriality is addressed by the obligation set forth by Article 3.1?
Your Excellency, Article 3.1 states that the contracting parties to this convention shall formulate and implement their planning. In this sense, what we argue is that considering that Camp Key is still it's still in discussion who actually has a sovereignty over this state. So in any case, the Ramsar Convention is applicable, seeing that both states here are parties to this convention. And as per Resolution 11.9, they have the obligation to compensate or offset any remaining impact. And further, this compensation should only be used as a last resort, being that the full conservation should be a primary choice. Moreover, as determined by...
But Agent, this resolution you're mentioning, is it a legally binding source of international law?
Your Excellency, according to the Institute for Water Education under the auspice of UNESCO, the resolutions of the Ramsar Convention are binding, but there is no mechanism to enforce them. So there are some scholars who defend that the resolution does, they exhort the state rather than obliged. However, Article 6.2 of the Ramsar Convention states that the conference of the contracting parties shall be competent to adopt resolutions or recommendations. Moreover, Article 7.2 states that these resolutions will be voted by the contracting states parties. Seeing that these resolutions were then approved by the majority, they should be binding upon the state of RONGO.
Perhaps, but this resolution also allows for mitigation measures. Now, why shouldn't this court consider that mitigation at a certain level was indeed adopted?
Your Excellency, I understand your concern, but we must consider that the only mitigation measure that RONGO has presented is the window tinting or the implementation of shade screens on windows and doors that would face the beach. And even then, it would allow for spotlight use for safety purposes. In this sense, they have not presented any compensation or mitigation or offset measures for the destruction of the wetland on which the proposed hotel will be built upon. they only presented a mitigation measure in relation to the Royal Ridley sea turtles' natural habitat. And as determined by the CBD, states have, in accordance with the Charter of the United Nations and the principles of international law, the sovereign right to exploit their own resources, pursuant to their own environmental policies. In this sense, as Camp Key is only being occupied by Rongo, Rongo does not have the right to ensure activities or to control or moreover to cause damage to the environment of this natural reserve beyond their national jurisdiction. Moreover, it is important to, as I mentioned before, the wetland loss foreseen by the proposed construction is not unavoidable and must therefore abide by the provisions for its full conservation. The resolution 11.9 states that in any event of unavoidable impacts, the state should mitigate any loss through the restoration of the area. However, Your Excellency, we reaffirm that Rongo has not presented any project to minimize the intended impact. Moreover, the wise use of the area comprises the balance between ecological conservation and sustainable development. And as documented in recommendation 2.3 of the Ramsar Convention, when the transformation of the wetland is planned, it is the state's duty to provide measures to mitigate or exclude any adverse effects of wetland transformation. Seeing that there was no change in the status as a Ramsar site, seeing that neither UNHUR or Rongo requested the delisting, nor submitted any notification for the Secretariat requesting said deletion of the site from its list, as prescribed by Article 2.5, the skewed coastal wetland must be considered a Ramsar site. In addition, the Vienna Convention on the Law of Treaties from 1969 notes that the principle of good faith and pacta sunt servanda rule are universally recognized. In this sense, by being a signatory to both the Vienna and the Ramsar Convention, Rongo must comply with its obligations in good faith, carrying out its liabilities and duties.
Agent, you mentioned the pacta sunt servanda from the Vienna Convention, the Law of Treaties. Is there any exception recognized is there any exception concerning this principle?
Yes, Your Excellency, the exception that arises from the pacta sunt servanda rule are when there are exceptionally situations that the state did not know when they complied, they acceded to the convention, which we are arguing that this is not the case. Okay. Now, if I may move on to my second point, the biodiversity of the...
Before you do that, Agent, please clarify to this court, why shouldn't the hotel be considered sustainable ecotourism? And also a means to fulfill the human right to development.
Your Excellency, the applicant claims that Rongo should apply the no net loss strategy to counterbalance the impact of the construction plan, which would allow for the ecological change while simultaneously imposing the obligation to restore or create at the level of the totality of the wetland resource. As I mentioned, this is not being applied by the respondent state, as they did not have presented any compensation measure for the degradation of the environment. Now, if I may move on to my second point, the biodiversity of the skewed coastal wetland is protected under international law. And I will mention the economical and social rights of the local population in just a few minutes. The Arab Charter and also the African Charter on Human and People's Rights both provide the human right to a healthy environment and establishes the duty of combating environmental pollution as a measure to fulfill said right. Moreover, the government of UNHUR, in accordance with the Declaration of the United Nations Conference on Human Environment dated from 1972, all development must bear in mind the need to safeguard and improve the environment. Moreover, the African Court on Human Rights, in the case of Social and Economic Rights Center and the Center for Economic and Social Rights versus Nigeria, decided that a government's lack of action to stop the contamination of the environment resulted in a violation of the right to a healthy environment. In this sense, Rongo's intended hotel complex violates its obligations arising from the Stockholm and Rio Declaration, as the state not only tolerates, but also encourages irreparable harm to the skewed coastal.
Agent,
Moreover,
considering that in this same case, your country is at the same time accusing the other country of provoking environmental harm, and then asking this court to consider that in another aspect of the same case, your state did not violate environmental obligations, I ask you, does your state come to this court with clean hands?
yes, Your Excellency, the applicant submits that environmental impact assessment was done by Rongo, but is not compliant with international law. But UNHUR, as stated by my co-agent, reaffirmed its commitment to its international obligations by conducting an impact assessment of its actions beforehand, and therefore planned for the attack only to be done as necessary.
But was it an environmental impact assessment or a proportionality assessment?
It was a proportionality and necessity assessment. In this sense, the environment was taken into account as well in said assessment. Moreover, Excellency.
Agent, before you proceed, you mentioned the environment impact assessment. How this court defined some standards for a good environmental impact assessment?
Your Excellency, I would present to this court the Pope Mills case, but I do have here in my hand the Convention on Environmental Impact Assessment in a transboundary context from the UN Economic Commission for Europe, which sets out how these impacts should be done, and they should have a description of the proposed activity and its purpose, a description where appropriate of reasonable alternatives to said project, but it has a list of requirements, but more importantly, in having the context of transboundary harm, the state that is planning to do this activity has to inform the state which will has to notify and consult other cases who will likely have the impact also in their jurisdictions. As I mentioned before, I can also cite the Pope Mills, in which the court has this determined that it is for each state to determine its domestic legislation or in the authority process the specific content of the environmental impact assessment. But as I mentioned before, seeing that UNHUR still considers Camp Key as part of its territory, and Rongo is making the same claim in other fora, neither state should do any act that will harm the environment without consulting each other. Now, if your honors allow, I will move on to, if your excellencies permit, I will move on to my third and final claim that the economic rights of the local population cannot suppress the right of the environment. Your excellencies, there is a growing legal recognition of nature itself as a subject of rights, and a number of states have already enshrined the rights of nature in their legal systems, such as Ecuador and Argentina. Moreover, we have the case of the Constitutional Court of Colombia that sustained that nature has the right to be respected in its entirety, instead of adopting the comprehension of nature as a mere resource. Moreover, the Constitutional Court of Colombia found that other living beings are worthy of protection in themselves, and that justice of nature must allow it to be a subject of rights.
So is it a regional custom applying only to South America, or is it a general rule of international law?
Your Excellency, this has, I gave examples of state practice that occurred specifically in the South American context that had also the advisory opinion 2317 of the Inter-American Court that has decided that the human right also to a healthy environment. Now, I see that my time is almost up, so I will proceed to my prayers. If I may have 30 seconds just so that I can conclude it.
Yes, yes.
Thank you, Your Excellency. The applicant hereby requests the court to declare that, firstly, the federal state of UNHUR did not violate international law with respect to the man-made wetland complex. Secondly, that the respondent, the Republic of Rongo, violated international law with respect to the proposed hotel development. And if your honors have no further questions, I shall rest my case. It was an honor to argue before this respectable court today. May it please the court.
Thank you, thank you. Perfect timing concerning the 30 seconds that were added. I kindly ask the court staff to also give the same amount of time to the team of the respondent if they need it. Now, the first oralist for the respondent may have the floor.
Good afternoon, Your Excellencies, agents for the applicant, may it please the court. My name is Livia Chavez Marcolin, and with my co-agent, Mrs. Ana Beatriz from team S2653, I have the honor of appearing on behalf of Federal States of Congo, the respondent in the present case. In today's proceedings, I will be discussing for 15 minutes why UNRWA violated international law with respect to its military strike, because the applicant has firstly violated international law, and secondly, is not entitled to any circumstance precluding wrongfulness. In conclusion, the applicant has the duty to compensate Congo for the damage caused. First, regarding the violation of international law, the applicant has violated the customary duty to protect the environment even under an armed conflict. Considering that this situation fits into the determinative elements of an armed conflict according to the IHL, which is when one or more states resort to the use of armed forces against another state, it is clear that in this context, the environmental protection must be regarded as an important customary international law. The customary duty to protect the environment was violated since this provision is customary according to the Rule 44 of the IHL. While conducting military operations, all physical precautions must be taken to ensure the preservation of the natural environment. In order
Agent.
Yes.
Yes.
No, please go ahead, brother judge.
Okay, agent, you mentioned that there is a customary rule concerning this protection. I would like to know where we can find the state practice and the opinion juris of this customary law.
Yes, Your Excellency, this principle was provided in an advisory opinion of this court in the nuclear weapons case. And the precautionary principle indicates that lack of scientific certainty certainly is no reason, to postpone an action to avoid potentially serious or irreversible harm to the environment. So this principle is a customary law because it was already recognized by this court, and it is in diverse international law, including.
Okay, agent, but I know that this case, this court has its clear position concerning this customary rule, but how this court achieved this position? So to achieve this position, the court observed the two main requirements for customary law, the state practice and the opinion juris. So where this court find the state practice and where this court found the opinion juris?
Okay, so I understand that this court find the opinion juris and the state practice and a lot of conventions signed by the countries, including these countries, including the Ramsar Convention, and there is a lot of customary law, including the proportionality principle, the duty to cooperate, that are related to this customary principle of protecting the environment. And it is also foreseen in the Rio Declaration and the Stockholm Declaration. So with that, it is reasonable to consider that it is a customary international law.
So these documents are examples of state practice or opinion juris or both requirements?
We understand that both, because the state practice is, we can see the state practice of these states by signing those conventions. And the opinion juris is also confirmed when these countries agree with this principle as a rule that they are submitted to. Besides, during times of armed conflicts, the environment must be protected as an important civilian object, which comprises all objects which are not military objectives, according to the ILC and the IHL. Indeed, UNRWA breached the customary principle of distinction between civilian objects and military objectives, which only allows for attacks directed to military targets. On the basis of the civilian character, any part of the natural environment that is not a military objective must be protected not only against direct attack, but also against incidental damage, which must not be excessive.
Agent,
Yes.
should this court still consider the area as having a civilian character, even after all the people that were there were relocated? I mean, there were no civilians anymore there, so why should we apply a rule of international humanitarian law, considering that the area is of civilian character, since there's no civilians?
Indeed, there are no civilians living there, but the environment is a civilian object, according to the ILC and the IHL, and also is a place that is really important for the humanity to survive. The protection of this area is important for the humanity as a whole. So, according to the IHL, it is prohibited to use methods that do not distinguish between combatants and civilians because severe and long-term damage to the nature and cause severe and long-term damage to natural environment.
So Agent, you presented the ICRC as basis for your claim. Now
Yes.
I ask you, is it the pronouncements by the ICRC, are they a hard source of international law? What kind of source are they?
Actually, Your Honor, despite them not being binding to the states, they shall be taken in consideration as a subsidiary means to this court according to the Article 38 of the statutes of this court. So, UNRWA violated its duty not to cause transboundary harm, which is considered an important customary environmental law, recognized by this court on its judgment on the Pulp Mills case and on the Pulp Mills case, and it is also provided by the CBD's Article 3. According to the draft articles on prevention of transboundary harm occurs when there is a significant consequence to an state's environment and or wildlife as a result of human activities held in another state's territory. Thus, UNRWA violated this principle by launching explosive rounds artillery, which provoked a high-scale fire that burned 1/3 of Rongo's environmentally protected area. UNRWA has not acted with due diligence, which was established in the present court in the cases of the Corfu Channel, Pulp Mills, and in the construction of the road along San Juan River in Costa Rica. Because although it was aware about the presence of civilians engaging in guided tours in the manhit wetland, it proceeded anyhow with the reckless launch of explosive artillery rounds. Also, the proportionality analysis conducted by the applicant has provided convincing evidence that there would be a certain serious and irreversible injury to Rongo if UNRWA undertook the strike, notoriously resulting from the possible damage to civilians. Also, there was a violation of the proportionality principle, which was already recognized as a customary principle by this court in the case of Nicaragua versus USA. According to the 14th rule on customary IHL, excessive damage to civilian objects in relation to the concrete and direct military advantage anticipated is considered a violation of the proportionality principle. By launching 200 high explosive artillery rounds at the camp, UNRWA caused a fire that devastated a portion of the pet swamp, equivalent to an area of almost 113,000 soccer fields, or 800 square kilometers, which is more than the whole area of the territory of Singapore, resulting in a yes.
forgive me, agent, but if the applicant was not authorized to adopt the measures that it took, what kind of alternatives do you think the applicant should have considered to deal with the peril imposed by the paramilitary group? What would be the alternatives?
Your Excellency, we understand that the applicant should have acted in cooperation with Rongo. In accordance with the CVD, there are still Article 41.1 and the Stockholm Declaration, which was also provided by this court in the Gabikov-Nagimaros project judgment, which considers the need for a common outlook and for common principles to guide the countries in the preservation of the human environment. This implies that UNPOR should contact Rongo before taking action, aiming for cooperation to solve the situation. If UNPOR had acted in cooperation with Rongo, both countries could have tried to solve the situation without any harm to the manmade wetland, which is the conduct expected by any nation that has an issue into another country territory. Also aiming not to violate the other state's sovereignty. Hence, cooperation could have changed the situation and avoided the damage. Also, the provisions stated in the Ramsar Convention were violated because this convention should apply even in times of armed conflicts. According to the guidelines on the protection of the environment in times of armed conflicts, the International Environment Agreement and relevant rules of customary law may continue to be applicable in times of armed conflicts. Also, several multilateral environmental treaties that directly or indirectly provide for their application in times of armed conflicts, including the World Heritage Convention, of which both countries are signers. Also, the obligations concerning the protection of the environment that are binding on states party to an armed conflict and that relate the areas beyond the limits of national jurisdiction are not affected by the existence of an armed conflict. The man-made wetland complex is a Ramsar site. As explained, the Ramsar Convention is applicable during armed conflicts. Also, this document applies to situation of urgent national interest and national security according to the United Nations Environmental Program protecting the environment during armed conflicts. Moreover, it is important to clarify that Rongo did not submit an Article 3.2 report about the 2014 drought because the writing of the article clearly states that changes caused by human interference such as pollution or technological development, which constitute traceable interference, must be reported. As soon as the cause of the drought is not traceable, this was not a situation that fits into this article. Furthermore, the applicant sent drones which were capable to make the applicant see the conditions of the man-made wetland complex of a drought. So the applicant cannot claim that it did not know about the condition. Also, UNHCR sent a diplomatic note on 10 February 2020 stating that the drought is part of the natural landscape of the Ramsar site. Thus, it is clear that it knew about the possibility of the fire spreading before taking action. Furthermore, yes?
Now, I understand that you're arguing that the applicant had a duty towards the wetland complex based on Ramsar. Now, I ask you, didn't your country also have a similar duty regarding the skilled coastal wetland? And if so, does your country come to this court with clean hands?
Yes, we understand that we come to this court with clean hands, considering that we didn't violate any international law. With this attack, UNHCR violated both principles of sovereignty and prohibition of the use of force of UN Charter Article 2. The UN Charter Article 51 gives two exceptions for the use of force, self-defense and the Security Council authorization. Neither of these situations applies in this case. because there was no authorization and the self-defense criteria according to the Nicaragua judgment of 86 is an armed attack, necessity, and proportionality. As exposed, the proportionality principle does not apply, was violated actually in this situation. And according to the draft articles on responsibility of states for international wrongful acts, the principle of necessity may not be invoked by a state as ground for precluding the wrongfulness of an action. Can I finish my submission, please? 30 seconds.
Yes, please.
Thanks. As ground for precluding the wrongfulness of an act not in conformity with an international obligation of that state. In this sense, the applicant is quite the opposite in face of the devastating fire sparked in the wetland, which is a civilian object. In conclusion, I would like to claim on whose duty to compensate for the damage caused. Under RCWA's Article 27B, the Ramsar Convention, the ILC articles on transboundary harm, the ILC report, and the case of Nicaragua versus Costa Rica that was insured by this court. Thank you. It has been an honor arguing before this court.
Thank you. Second oral is for the respondent. You may have the floor.
Good afternoon, Mr. President, members of the court, and agents of the applicant. My name is Ana Beatriz Oliveira from Team 2653, and I'll be arguing today on behalf of the Republic of Congo, the respondent in this case. My arguments concern the second point addressed to this court, which is the intention of Congo to build a hotel complex in the Sud Coastal Wetland in Camp Key, and as we made explicit despite the protests against it, it is the fact that the actions of Congo with respect to the proposed hotel development do not violate international law. Describing the order of the arguments, the agreement with the Article 3.1 of the Ramsar Convention would be attested first, along with evidence of important aspects of ecotourism according to Resolution 11.7, in order to better explain its benefits. Secondly, compliance with the IAC and the CBD will be certified. And finally, will be presented a concordance with resolutions 11.9 and 13.24 to certify that none of the allegations made in the diplomatic note sent by ANHU are valid. Firstly, Your Excellencies, it is worth clarifying that the non-recognition of the Sud Coastal Wetland as a Ramsar site is not due to the non-recognition of its high biological value and its ample diversity of flora and fauna. It is because of a bureaucratic matter. The sovereignty government, the country in which the wetland is part of the territory, has to designate it as a so-called Ramsar site. And since the process of designation is connected with ANHU, which no longer holds any powers over the region, Congo does not consider the Sud Coastal Wetland as a Ramsar site. And on this point, it is also worth mentioning, although the sovereignty of Camp Key is not a subject of this first decision, that 9 members of the United Nations have formally recognized the territorial integration of Camp Key into Congo. Hence, in order to certify the legitimacy of this non-recognition, Article A of the ILC draft articles on succession of states in respect of treaties clarifies that the treaties of the prestigious state are no longer valid from the date of succession of the states. Therefore, since 20 May 2020, date when 96% of the Indian people voted in favor of Camp Key being a province of Congo, it is not Congo's obligation to recognize the Sud Coastal Wetland as a Ramsar site. Addressing on the first point.
Agent, before I proceed, concerning this rule that you mentioned that the street is no more valid for this state, do you have any example that goes on the same line as your arguments?
Your Excellency, I can state a case judged by this court, the case of Camp Voko Nagamarus. This case deals with the dispute between Ukraine and Slovakia on the construction of barrages on the Danube River. And the ICJ held that Ukraine was not allowed to end a threat and that it remained in force between the parts. However, in this present matter, we have no intention to terminate the connection with the Ramsar Convention. We just, for bureaucratic reasons, do not recognize the Sud Coastal Wetland as a Ramsar site. But this in no sense removes the obligation under the convention to conserve and make wise use of the wetland. And citing this case, it is also worth mentioning that the court ruled that the parties should pay attention to the environmental effects of the power plant. It was noted that environmental impact assessment is required as a matter of customary law, particularly with regard to activities that may cause significant transboundary fact. This has already been duly followed up the present matter, as will be more detailed later.
Agent,
So, yes, Your Excellency.
I'm concerned with what Article 4.2 of the Ramsar Convention provides. Now, this article does provide that a country may delist or reduce the boundaries of a Ramsar site, but neither the applicant nor the respondent has delisted the skilled wetland coastal wetland. So therefore, the area would remain being a site of importance to international law, wouldn't it?
Your Excellency, just to clarify, we do not consider this coastal wetland as a Ramsar site for bureaucratic matter, but this does not change the obligation to conservation for the wetland. It's more of a bureaucratic. In any case, when there is a change in the list, which will be provided further, the standing committee should arrange for the information to be circulated for discussion at the next meeting of the conference in accordance with Article 8.d. So it is a subject that is still to be discussed in the future. But addressing the Article 3.1, it contains an obligation on wetlands included in the list, which technically does not apply. However, Article 4.1 also mentions the conservation of wetlands, whether they are or not included in the list, and the proposed project fulfills this demand, Your Excellency. In order to succinctly attest this fact, because it will be subsequently detailed, it is appropriate to mention essential characteristics for the particular identification of ecotourists provided by the United Nations Waters Organization and used by the Ramsar Convention. It's stated in Resolution 11.7, specifically in items 4 and 5, Annex 1.p, it is quoted that ecotourism minimize negative impacts upon natural and sociocultural environment, and it supports the maintenance of natural areas with or used as ecotourist attractions by generating economic benefits for host communities, organizations, managing natural areas with conservation purpose, providing alternative employment and income opportunities for local communities. These presented characteristics, Your Excellencies, completely in line with the proposed project, work well to synthesize the benefits of the execution of this project for the local community, and to reiterate that the ecological aspect is not left aside, quite the opposite. It is intrinsic in the purpose of ecotourism. And
Agent,
regarding, yes, Your Excellency.
You quoting Resolution 11.7, I understand your submission, but this resolution also expressly incorporates Resolution 11.9, which reaffirms the Convention's call to avoid negative impacts. So could you elaborate more on that obligation as well?
Your Excellency, this convention, this resolution, 11.9, talks about three-step approach. That is one, avoiding impacts, two, mitigating impact, and three, compensating for remaining impact. On page 12 of this resolution, establishes guidelines for mitigating and compensating, and it is presented a table describing the level of responses according to the identification of the level of risk in certain circumstances. In the case of the proposed project, a likely chance of interference of the lightning in the Rurality has been identified by the EIA, requiring the use of measures to contain this possibility. Thus, it can be identified in the table presented that the chance of occurrence of the risk as well as its impacts are low. Thus, described that the risk in the resolution is acceptable. Thus, a project can proceed, but needs to mitigate and monitor it, which we are fulfilling.
What were the measures that your country adopted in terms of mitigation?
Your Excellency, the environment impact assessment indicated correctly a possible interference of the light pollution to the Rurality. So we'll be installing shade screens or window tinting in windows and doors facing the beach to block interior light.
And how is this enough? Are there any other impacts that are not being mitigated by this measure?
Your Excellency, light pollution is a serious problem affecting many tourists in the world. It destroys natural ambient pattern and confuses hatchlings. So our EIA correctly identified this threat and with the proper research indicated sufficient measures to solve them. Its reliability can be attested from the Article 5 concerning turtle nesting protection, published in 2009 by the Miami government in order to protect sea turtles of Miami Beach. The solution in the article is precisely to restrict artificial light by installing tinted glass or shade screens on windows and doors facing the beach. Thus, it's a well-known measure used by states exactly because of its protective capacity. But concerning a fact that I think you're implying, that the lighting will be maintained in the marina as well as in other spots for safety purpose. But however, it should be clarified that the use of spotlights was mentioned in the EIA, but not specified. So I understand the questioning and is an excellent additional for explanation. With the EIA having identified a possible interference of light pollution on Royal Ridley and the need for measures to address this, it is clear that there can be no contradictory propositions. So, although not detailed appropriately, the choice concerning the spotlights will be from sea turtle-friendly fixtures as well as sea turtle-friendly bulbs. As example, lights that are yellow, amber, or red. These sea turtle options are listed on the official website of the Sea Turtle Conservancy. Regarding the wise use principle, Your Excellencies, it is also no violated. The concept of wise use considers the context of sustainable development, and as described in the wise use article on the official site of the Ramsar, wise use comprises the sustainable use of wetlands for the benefits to people and nature. And an excellent ecosystem approach to answer this is ecotourism. Secondly, Your Excellencies, it is important to mention relevant facts brought about resolutions 11.7 that is dedicated specifically to tourism. Already in paragraph 1, it is stated that wetlands are the most productive natural areas, being both coastal and inland, excellent ecosystems for the provisions of services such as the development of sustainable tourism. Also following paragraph 1, it is marked that such services can offer both material and non-material value to a government. Thus, the project in the Scoot Coastal Wetland, which house both inland and coastal parts, not only offers a structure of a hotel complex on the basis of sustainable economic development, but offers values linked to a culture of care, of ecological balance and protection, of sustainable interactions between the community and the ecological heritage. In paragraph 13, the resolution identifies the relevance of sustainable tourism for poverty eradication, which is completely in line with the objectives announced by the Rwandan Ministry of Environment and Sustainable Development. And this complies with a very essential goal established by the United Nations on the 2030 Agenda for Sustainable Development. Moreover, goals such as decent work and sustainable economic growth and sustainable communities are also embraced for this project.
Agent, indeed, your state is allowed to pursue its development in a sustainable manner. We can all agree with that, but nonetheless, shouldn't your state consider creating this hotel complex in some other area? Did it pursue alternatives before putting it so close to the nest of endangered species?
Your Excellency, we do have a wetland that could be construction on the mini hydroelectric complex, although now it is in very less similar conditions. But it's important to point out that we were used to the presence of a wetland, the mini hydroelectric complex, that is designated as a national park without the presence of human habitation, although it has the presence of tourists sporadically, and the Scoot Coastal Wetland provides livelihoods for the local community. So it is an appropriate place for ecotourism to provide opportunities for more sustainable interactions between the inhabitants and the region.
Did your country consult with the locals, with the local communities?
Your Excellency, the project is still not in execution because we agreed to wait until this court's decision. So I believe this is not present in the report, but for sure, as we conducted properly an EIA, the contact with the local community will be certified. And addressing the IAC, the pronouncing objective of the convention is the conservation of sea turtles population, taking into account the environmental, socioeconomic, and cultural characteristics of the parts. Camp Key is a small island, thus already has more difficulties to achieve development, being more vulnerable, as attested in paragraph 22 of the 2030 Agenda for Sustainable Development. The execution of the project, which strategically takes advantage of the ecological heritage of the region, is an essential instrument to achieve better social conditions for the local community. Hence, conservation, in the case of the Scoot Coastal Wetland of the Royal Ridley, needs this reality to be taken into consideration. Rongo also complies with paragraph 1 of Annex 2, which requires an environmental impact assessment, and with the second paragraph requirement to regulate the use of artificial lights. And as presented in paragraph 36 of the report, the EIA indicated that the lighting of the proposed hotel would likely interfere with the nesting habitat of the rhyidly, a species very important for the wetland, and had indicated measures sufficient to its regulation. So it is important to stress that an environmental impact assessment, as reaffirmed by the case concerning the construction of a road in Costa Rica and the pulp mills, that we are properly following national law to do the environmental impact assessment, is an obligation to prevent transboundary harm, which we have properly fulfilled. As indicated, it is very important. It is very important to make an analysis of the reality before the territorial integration. The Escute coastal wetland, according to the description on the Ramsar site information sheet, as presented in paragraph 17 of the report, among other threats, suffers from inappropriate agricultural practices, subsistence hunting, overexploitation of marine resources, and development pressures. Thus, it is common knowledge of the worrying reality of the wetland suffering from several harmful activities. Therefore, the intended development for the region is not a threat, but a fundamental instrument, the development for the economic growth and the enjoyment of the wetlands by all citizens, and not only by those who do it in a distorted manner. Although the project only covers 6% of the total area of the wetland.
Agent,
besides,
I see that your time is up.
I will use the 30 seconds. Can I? I'm sorry for interrupting you. Because I will use the 30 seconds that you mentioned. I'm sorry.
Agent, yes, that was all I was about to say. So I see that your time is up, but you may have 30 additional seconds to conclude your submissions, please.
I'm sorry. It's because you mentioned before, I thought I could continue into 30 seconds. I'm sorry. Although it only covers 0.6%, Your Excellencies, besides guaranteeing that in the space of the hotel complex, there will not have harmful activities, safeguarding species such as the royal ridley, the presence of ecotourism has the capacity to introduce and expand a culture of protection. With these considerations, I conclude my speech, and I thank you for your time. It has been an honor to argue before this court.
Thank you. The oralist for the applicant may have the floor if she so wishes to present her rebuttal.
Your Excellencies, the counsel for the applicant shall address some brief points on the rebuttal as brought by the learned arguments of the respondent. First, Rongo knew of the attack. Second, Rongo failed to submit an Article 3.2 to inform the Ramsar Secretariat about the ecological change at the Manhit Wetland Complex. And third, that the proposed complex did not consult the local population. Proceeding to the first topic, according to answer 10 of the clarification of facts, Rongo knew that the MPFF had established a camp in the Manhit Wetland Complex. Moving on to the next point, Article 3.2 of the World Heritage Convention is useful to notify if the ecological character of a Ramsar site has changed as a result of human interference, and this notification must happen in the earliest time to the proceeds be taken and the necessary done to preserve the area. Therefore, in 2014, when an extended drought started due to climate change and adversely affected the ecological character of the Manhit Wetland Complex, the respondent had the obligation under this article to notify the Ramsar Secretariat. But until 2019, no actions were taken. And since climate change is attributed, the attributed cause of the drought is a consequence of human interference, even if it is not traceable, it meets the demand of Article 3.2. So when UNHCR made the attack, it had no knowledge about the drought situation, which given the characteristics of the Ramsar site, led to a drastic situation of the fire. And finally, the local population did not participate in the decision-making process as required by the Resolution 8.8, which urges contracting parties to include the extensive consultation with local communities in the formulation of national wetlands policies and legislation. Unless I can give any further assistance to this honorable court, this concludes my submissions. It was an honor to argue before this court today. I shall rest my case.
Thank you, Agent. Perfect timing.
Thank you, everyone. The session is now adjourned. Now we'll take the judges to a separate room to deliberate. You may remain here and we'll be back in around 5 to 10 minutes with feedback. Judges, you will see an invitation pop up on your screen in 1, 2, 3. Yeah. Henrique, por favor, fique à vontade.
Olá, pessoal. Agora a gente pode dar uma respirada, né? Relaxar um pouquinho. Foi uma rodada interessantíssima. Permitam-me, antes de tudo, cumprimentar as duas equipes. E eu falo em meu nome e em nome dos meus colegas de bench. Nós gostamos demais dessa rodada e desfrutamos muito do conhecimento de todas vocês e queremos parabenizá-las, né? Nesse momento, a gente aproveita para se conhecer um pouco melhor, cada um de nós vai se apresentar e também para passar algum tipo de feedback sobre a rodada. Ao final, nós iremos anunciar qual das equipes vai para a rodada final, né? Vai se classificar para a rodada final. Eu vou começar só me apresentando e já passo a palavra para a minha colega, a doutora Tamires Loduca, para ela se apresentar e apresentar também o feedback dela. Depois o doutor Ivonei se apresenta o feedback e no final, se tiver alguma coisa de feedback, eu apresento e anuncio o resultado. Tudo bem? Bom, eu sou Henrique Napoleão Alves, eu sou advogado e professor e atuo como advogado na Comissão Interamericana de Direitos Humanos, e especificamente no sistema de petições e casos da comissão. Então, vivo o direito internacional na prática, né, diariamente, mas apenas lateralmente com foco ambiental. Vez ou outra aparece algum caso interessante, inclusive de direito humano ao meio ambiente sustentável. Eu gostei de ver aí o pessoal argumentando com base nisso também, né? Foi interessante. Então, é mais para mim uma oportunidade aqui na Stetson de aprender com vocês e eu faço questão de, sempre que eu posso, vir participar. Já participei muito de competições assim como essa, como juiz, e por isso também quero aproveitar para convidar vocês a continuar fazendo parte da nossa comunidade, né? Sejam como participantes de novo ou de alguma outra competição, mas seja também como juízes, né? Não é tão divertido, mas é próximo disso, por isso a gente tenta voltar todo ano aí, e é meio que um curso que a gente faz de atualização em direito internacional ambiental, pelo menos assim eu considero. Doutora Tamires.
Pessoal, boa tarde. Reitero aqui os cumprimentos do meu colega, doutor Henrique. Eu sou advogada, ao contrário dele. Eu milito no direito ambiental aí diariamente, e aqui para mim é uma pós-graduação em direito internacional. Então, eu estou aqui um pouquinho na outra ponta. Quero parabenizar todas pelo alto nível de argumento nos debates aqui. Foi realmente um aprendizado para a gente que está aqui julgando. E como feedback que eu queria deixar aqui para vocês é para vocês sempre tomarem cuidado com o ambiente externo, isso assim para a vida profissional de vocês, porque eu acho que isso pode influenciar e muito no momento em que você está despachando com um juiz ou que você está fazendo uma petição, momento assim de concentração. Também eu acho muito bom que vocês fizeram uma linha introdutória da argumentação, e só toma cuidado para não ficar sempre preso a isso, e também quero parabenizar ambas as equipes pela forma que vocês discursaram e que apresentaram o caso aqui para a gente. Passo a palavra para o doutor Ivonei.
Olá, gente, tudo bom? Prazer enorme estar aqui com vocês nessa tarde aqui de uma rodada da Stetson Outro Porto. Então, quero me apresentar. Eu sou Ivonei Souza Trindade, sou advogado aqui em Porto Alegre, sou professor de Direito Internacional dos Direitos Humanos de uma instituição no Peru chamada APARIMUN, Instituto de Investigação e Debate em Direito. E minhas áreas de pesquisa nos últimos anos têm relação tanto com o sistema interamericano de direitos humanos, como também direito internacional do patrimônio cultural. Então, esse caso me chamou, esse caso fictício, eu gostei muito porque tem uma conexão muito forte com direito internacional do patrimônio cultural, com alguns temas que vocês vão encontrar bases de jurisprudência, uma base jurisprudencial boa no sistema interamericano também. Então, esse caso é um caso muito rico para explorar vários argumentos, né? Então, e foi o que nós pudemos ver aqui nessa rodada, assim, argumentos riquíssimos, assim, muito bem levantados pelos dois times. Então, quero parabenizar as 4 oradoras pelo excelente trabalho que vocês fizeram. Deu para observar que vocês realmente se debruçaram com afinco na jurisprudência, nos documentos legais que vocês trouxeram aqui. Então, só isso daqui é valiosíssimo que vocês construíram, né? É um conhecimento construído, né? Então, por isso que o Multiport, eu também fui participante, sou participante como avaliador junto com o meu amigo professor Henrique. Então, é o que eu digo sempre em algumas rodadas, eu sempre comento assim, olha, o Multiport, por que o Multiport ele é tão uma experiência que marca tanto a vida de uma pessoa que participa? Porque é um conhecimento que a pessoa constrói, né? Durante até o momento da rodada, pós-rodada, então é um conhecimento que está sempre sendo construído, né? Por exemplo, aqui vocês vão sair da rodada, vocês vão sair com vários insights, assim, pensando, putz, acho que podia pesquisar mais isso, podia melhorar isso, putz, tal ponto, talvez eu possa desenvolver uma pesquisa, virar uma monografia, virar um artigo, então por isso que é bacana essa experiência de muito forte, dessa construção que vocês fazem, né? Então, por isso eu digo aqui para, por favor, continuem envolvidos com esse universo do multi, assim, porque todos nós aprendemos, nós que somos judges aqui, nós também aprendemos, tem pontos que, quando na primeira leitura do caso a gente tem uma percepção, aí lemos os memoriais, quando for o caso de ser avaliador de memoriais, temos uma outra, chega nas rodadas, tem uma terceira percepção, né? Então por isso que é valioso. E às vezes uma quarta percepção depois que termina a rodada e vem as outras insights, né? Então, por isso que é uma experiência tão enriquecedora participar de Multiports. Eu tenho alguns comentários assim, gerais para vocês, aqui, tanto para o time que vai avançar para o final, quanto para o time que não avançar, mas que fique como uma dica assim, para eventos futuros que vocês venham participar, outros tipos de Multiports, para vocês prestarem atenção. São dicas que valem para vários Multiports que sejam nessa sistemática do Stetson, né? Então, primeiro ponto, um ponto que eu quero chamar muita atenção, muito valioso, que é a questão do gerenciamento de tempo do discurso de vocês. Isso é um ponto valiosíssimo que vocês precisam prestar atenção. Por exemplo, se vocês estão vendo que não vão vencer, vocês precisam falar 3 pontos e vocês viram que, putz, falta ainda falar um ponto e falta 1 minuto ou 2 para vocês terminarem, né? Primeiro ponto, assim, não inventem de querer seguir o script nesse momento, que aí às vezes a pessoa, não, vou falar rapidinho aí, eu falei, joguei para a corte e deu. Não, isso aí pega mal, porque o juiz, ele não entende, às vezes a pessoa está falando muito rápido, e aí a gente quer perguntar, e a pessoa já está indo noutra, e não explicou o argumento, às vezes até pior do que não falar. Então é importante, quando vocês veem que vocês não vão vencer, tentem improvisar de uma maneira que consiga dar um fecho bonito no discurso de vocês. Seja resumindo o argumento em poucas palavras, o argumento que vocês teriam que explicar, sei lá, em 4, 5 minutos, tentar resumir em 1 minuto, resumir mesmo, assim, dizer pontualmente, ó, defendo isso, por isso, violando isso, deu, fechou o ponto. Ou se vocês veem que não vai vencer, tudo bem, tenta pelo menos fechar o ponto que vocês estão terminando e fecha o discurso de uma maneira bonita, mas não invente de querer seguir o script ou pôr pontos muito sensíveis, faltando 30, 40 segundos. Digamos, falta 20, 30 segundos, vocês querem inserir um caso muito delicado na argumentação de vocês, que pode gerar muitas perguntas. Evitem fazer isso, porque às vezes eles já estão nervosos com o tempo, ainda adicionam um elemento desafiador, com chance de um juiz bombardear vocês de perguntas, e ainda vocês não terminarem da maneira adequada. Então, tentem fechar de uma maneira redonda, né? Uma maneira mais bacana o discurso. Essa questão do gerenciamento de tempo é muito importante para vocês. Como a minha colega, a professora Tamires, falou também, reforça essa questão de prestar atenção nos elementos externos, isso aí é muito, muito importante, né? Muito importante prestarem atenção. Outra questão das perguntas, assim, aos juízes, né? Às vezes, os juízes, as juízes vão fazer vários tipos de perguntas para vocês em variadas maneiras, seja perguntas para testar se vocês estão a par dos fatos, se estão a par dos argumentos do lado contrário, ou às vezes até perguntas bastante objetivas. Às vezes é comum terem uma sequência de perguntas longas, daqui a pouco uma pergunta bastante objetiva. Então, quando for uma pergunta objetiva, ser objetivo na resposta também, estar na mesma sintonia que o juiz e a juíza. Eu sei que às vezes o orador até fica impressionado, não, mas nossa pergunta é tão direta, tão na lata. Então a resposta também tem que ser no mesmo sentido, né? Então não é porque é a pergunta objetiva e vocês falarem mil e uma coisas além da resposta que vocês estão mandando bem, às vezes está sendo prejudicial para vocês, porque vocês acabam perdendo o tempo de vocês, né? Um tempo valioso, né? Que poderia ser usado. Então estejam sempre na mesma sintonia ali das perguntas e respostas dos juízes e das juízas, né? E por fim, gente, eu gostei muito, assim, que os estilos das oradoras foram muito bons, assim, de estabelecer a rota, enfim, de como vai ser a argumentação, enfim, é muito bom, assim, para a gente que está avaliando aqui, é valioso, porque a gente vai indo na sequência e vai vendo como vocês estão indo, né? Conforme vai a rodada. Uma dica adicional que pode acontecer em alguma rodada futura, em algum evento posterior que vocês forem participar, é quando vocês enumeram os pontos, vou falar sobre isso, ponto 1, 2, 3. Tem juiz e juiz que gosta de chegar e dizer, olha, não quer começar pelo ponto 3 a partir de agora? Então, vocês precisam estar preparados para esse tipo de questionamento, assim, que um juiz ou uma juíza pode levantar para vocês de querer inverter a ordem. Então, vocês precisam estar preparados. Aqui nessa rodada não aconteceu, mas pode vir a acontecer um outro mútuo corte que vocês venham participar, né? Então é isso, gente. Eu fico à disposição, assim, eu quero agradecer demais aqui pelo convite, ao pessoal do evento e também agradecer às 4 oradoras por essa tarde, assim, ter fornecido tanto conhecimento aqui para a gente, né? Pontos que a gente não sabia, pontos que a gente não tinha feito conexão, enfim. Então, quero agradecer demais, assim, e parabenizá-las aqui pelo trabalho. Então, é esse meu feedback e muito obrigado.
Bom, pessoal, algumas considerações assim para cada uma das equipes e algumas que valem para ambas as equipes, né? Todas as equipes, gostei bastante assim de como apresentaram esse roteiro inicial de quais seriam os argumentos e também reitero ou faço eco com o que o Ivonei disse a respeito do cuidado de não ficar tão preso nisso, ou de navegar bem de um ponto para o outro, navegar com leveza de um ponto para o outro. Eu também fiquei muito contente assim de observar o domínio que todas vocês têm assim do idioma que é uma segunda língua, né? E vocês, enfim, têm um inglês perfeito e se pronunciaram de maneira muito clara, assim. Para o applicant, para o lado do applicant, importante, se citar algum fato e o juiz te perguntar sobre aquele fato, está preparada para indicar o parágrafo. Mas agent, isso está onde? Não, isso está no parágrafo 17, sei lá. É também importante ser estratégica nos argumentos, porque vocês passam alguns meses ou vários meses, enfim, se preparando e desenvolvem vários argumentos para aquele mesmo ponto. Na hora de apresentar na rodada oral, talvez não vai dar tempo, provavelmente não vai dar tempo de abordar todos eles ou todos eles da mesma forma. Talvez seja melhor, então, escolher os mais fortes primeiro e só abordar os mais fracos se tiver tempo. Então, exemplo hipotético, tá? Esse meu ponto aqui, usando a World Heritage Convention, não vai ser tão forte quanto o meu ponto com a outra fonte, então eu vou pela outra fonte primeiro, certo? Só para ilustrar. É também importante responder diretamente as perguntas. Então, sei lá, se o juiz está insistindo numa pergunta sobre proporcionalidade, entra nela e resolve, assim. E isso vale para todas as equipes, que é assim, não é obrigatório vocês adotarem essa forma, mas eu, pessoalmente, eu gosto muito quando as equipes fazem assim, fiz a pergunta, yes, no e por quê? Agent, e tal coisa? Você não acha que é isso? Não. Você pode dizer, é educado, né? Know your excellency because of 3 points. First, second, third. Então, talvez assim uma resposta mais direta, assim, sim e não, e apresentar por que você concorda ou discorda do que está sendo dito ou perguntado pelo juiz. Eu achei também que a gestão de tempo pode ser melhor para todas as equipes, mas também não foi um ponto tão sensível e mesmo a primeira oradora para o applicant conseguiu abordar todos os pontos que ela tinha prometido abordar no roteiro, né? Precisou de 30 segundos ali para o último ponto, e o último ponto era um ponto que talvez demandasse mais, né? Um pouco mais assim de tempo, porque envolveu um argumento de costume, mas se saiu bem, conseguiu fechar o discurso e fez um ótimo rebuttal. Gostei muito do rebuttal. E aí é algo que eu falo também para outra equipe, porque amanhã você vai estar na outra posição, ou depois de amanhã, ou enfim. Então, sempre que tiver no rebuttal, é realmente uma boa ideia focar em 2 ou 3 pontos no máximo. Nesse caso, o rebuttal do applicant focou em 3 pontos, eu gosto disso, dessa objetividade. Achei um pouco arriscado acrescentar no terceiro ponto um argumento que vocês não tinham apresentado antes. Foi um argumento que surgiu de preocupação dos juízes, né? Que é se o respondent tinha consultado com a população local ou não. É interessante isso, de observar o que os juízes perguntaram, o que talvez não ficou tão respondido, mas toma cuidado para também, enfim, tem que ter esse equilíbrio aí, é arriscado também inserir um novo argumento no rebuttal, mas gostei bastante. A segunda oradora do applicant em particular, achei que foi muito, muito bem nas respostas, se engajando com a gente. Talvez em um momento ou outro você pausou um pouco demais. Aí é interessante você tentar não fazer isso, porque isso pode convidar os juízes a te fazerem mais perguntas, e aí eles vão prejudicar o seu tempo, né? Então, essa mudança de um ponto para o outro, porque eu entendo, assim, é uma questão até de educação, você deu a resposta, você quer conferir se o juiz está satisfeito para você ir para o próximo, então, às vezes, você faz um silêncio e olha a reação dele na tela, né? Mas não precisa de tanta... É bom ter essa ser polida, mas não precisa de tanto também, não. Pode... deu a resposta e move para o próximo ponto, porque se o juiz não estiver satisfeito, provavelmente ele vai te interromper e te pedir algum esclarecimento. É assim a dinâmica, né? É a dinâmica dessa moot court. Na verdade, foi para essa oradora que faltou um pouco mais tempo para falar sobre direito ao meio ambiente saudável, mas conseguiu apresentar o argumento, cumpriu o que tinha prometido, e eu achei assim uma oradora muito, muito articulada, né? Teve um ponto ou outro, assim, acho que uma pergunta que eu fiz sobre direito ao desenvolvimento, que a resposta foi mais rápida, mas isso sou eu, que estava doido para ouvir um pouco mais sobre direitos humanos, entendeu? Direito humano ao desenvolvimento não é um ponto tão central assim, mas, enfim. Eu gostei bastante, de verdade, assim. Foi realmente uma exibição de alto nível, alto nível. E a equipe respondent também altíssimo nível, altíssimo nível. O que eu poderia dizer aqui são coisas para o seu aprimoramento, né? São detalhes que vocês podem incorporar e aprimorar a capacidade que vocês já têm notável de serem ótimas competidoras, né? Então, eu diria, assim, um cuidado com a formalidade, porque se for uma rodada em que as equipes não estão com níveis parecidos, ela não vai pesar tanto. Mas se for uma rodada em que as equipes são excelentes, esses detalhes podem pesar um pouco mais. E também tem juízes diferentes de nós não estamos nesse time, mas tem juízes que são, sim, super estritos com formalidades e vão dar peso para isso em qualquer circunstância. Então, evitar, por exemplo, na hora que você for começar a responder uma pergunta, evitar de falar ok, so, isso é muito informal. E essa corte é extremamente formal. Então, é melhor ir, quem sabe, pela minha sugestão de yes, Your Excellency, no, Your Excellency e as suas razões, certo? A oradora Lívia, o seu celular tocou, eu vi que você ficou nervosíssima com isso. Olha, acontece, minha querida, não fique nervosa nem
Desculpa,
chateada
eu
com
posso
isso.
falar?
Isso,
É porque eu posso falar rapidinho.
claro, claro.
Não, é que eu fiz questão de silenciar o celular e mandei mensagem para todo mundo para não me ligar. Nesse momento, não tocou o dia inteiro meu celular. E aí ele tocou no meio da minha fala. Foi uma coisa assim que me. Mas enfim, desculpa mesmo, gente.
Ó, você tem duas coisas para tirar dessa situação, na minha perspectiva. A primeira é se orgulhar porque você conseguiu administrar o nervosismo que qualquer um de nós teria diante dessa situação. Você conseguiu se equilibrar e finalizou o seu discurso. Então, isso foi muito positivo. A segunda é não deixar isso acontecer de novo, porque é claro que isso não pode acontecer. Imagina se fosse sei lá, você despachando com uma juíza, um juiz, né? Enfim. Mas é ótimo que tenha acontecido para você ter essas lições. Na verdade, assim, se não tivesse acontecido, você não teria esse aprendizado. E essa competição é fantástica por isso. Ela dá vários aprendizados. Eu achei que você também leu um pouquinho demais às vezes. Em alguns momentos da sua fala, você leu um pouquinho demais. Pode ler, não tem problema, todo mundo consulta anotações e tal, mas tenta evitar. Mas foi só em alguns momentos. Na maior parte do tempo, você fluiu super bem. Achei que você deu boas respostas, respostas sobre as questões básicas, assim, sobre fontes. Teve um momento ou outro que eu acho que você teve um pouco de dificuldade de entender a pergunta, o que o juiz queria. Então, teve um momento assim que o Ivonei, o que ele queria é que você desse um monte de exemplos de state practice. E você deu uma resposta tecnicamente brilhante de, olha, a definição de costume internacional é essa, esses são os casos da Corte Internacional de Justiça, mas ele estava querendo outra coisa, depois você chegou lá, né? Mas essa coisa de prestar atenção nas perguntas para pegar a essência, enfim, gostei muito e gostei de como todas as equipes, e Lívia apresentou muito isso em especial, mas todas as equipes souberam trazer aqui e ali elementos assim de jurisprudência, podem até aumentar isso daí, certo? Que é uma coisa que os benches costumam gostar, argumentos com base na jurisprudência, especialmente na jurisprudência da própria CJ, é sempre bom. Por fim, para a oradora Ana Beatriz, eu também achei assim, fala muito bem, muito articulada, né? Ana, não diga que você é do time 400 e alguma coisa, do time 600. Você começou o discurso assim, porque a gente está no role-playing, né? Na verdade, você é uma advogada em Haia, você está em Haia, na frente dos juízes. Eu achei que eles estão aqui, ó. Aqui eles estão comigo aqui no fundo. Então é um detalhezinho assim, mas é só para você se lembrar depois, não tem problema nenhum. Também gostei da maneira como você apresentou o roadmap no início e cumpriu os pontos que você quis apresentar. Eu diria para realmente uma coisa construtiva, mantenha a formalidade até o final. Então, quando o presidente do bench ou qualquer outro juiz ou juíza falar, você calma, Ana, calma. Ana estava ansiosa, não, mas eu tenho 30 segundos ainda, deixa eu usar, desculpa, deixa eu usar, calma. Espera que ele vai falar e tal, mas esse nervosismo é natural, bom evitar, né? E também achei que em alguns momentos você falou muito depressa, mas sabe o que é também? É porque vocês tinham muita coisa que vocês pesquisaram. Eu não sei se a equipe são só vocês duas ou se tem mais gente por trás, mas independentemente de quem são ou quantas são as pessoas, ficou evidente para todos e todas, né, que vocês fizeram muita pesquisa. E aí a Ana ficava naquela, cara, eu preciso mostrar para esse pessoal todos os casos que eu... E aí começava a falar muito depressa, todos os casos, os fatos, casando isso e aquilo e tal. Às vezes, melhor um pouco mais devagar, para a gente entender bem o argumento. Mas, assim, de toda forma, um trabalho realmente de alto nível, certo? Então, sem mais delongas, pessoal, eu vou anunciar esse resultado dizendo que, pelas observações que a minha irmã juíza e o meu irmão juiz fizeram e que eu fiz, está evidente que foi dificílima a decisão. porque são dois times excelentes, certo? Nesta oportunidade, avança para a final a equipe do Applicant. Parabéns a todas as equipes, a ambas as equipes, pelo excelente trabalho que fizeram. Parabéns. Parabéns.
Parabéns, pessoal.
Muito
Então,
obrigada, parabéns para as... Ai, desculpa. Muito obrigada,
Não, pode
queria
falar.
parabenizar as meninas também. Eu realmente não estava tão confiante assim, elas foram super bem. Então, parabéns e muito obrigada aos juízes por toda a consideração.
Parabéns a todas.
O
Parabéns,
Rui, a
pessoal.
gente esqueceu de fazer um
Parabéns.
registro, né, com a turma toda, né?
Fazer a
é.
foto? Pode
Isso,
ser,
vamos
sim,
fazer.
claro. Vamos lá. Vamos lá. Em 3, 2, 1. Pronto.
E no
Mais uma
mais,
foto aqui,
agora,
peraí.
terminada a rodada, somos amigas e amigos, certo? Então, aproveitem a chance também de se conectarem aí com as amigas e os amigos juízes. Olha só, eu falei isso na outra rodada semifinal, vou falar para vocês também. Algumas, ou várias, ou todas as pessoas que vêm aqui atuar como juízes e juízas são pessoas assim de alto gabarito do ponto de vista profissional. A doutora Tamires, responsável pela área ambiental de um grande escritório brasileiro, um dos maiores. O doutor Ivonei é a nossa referência para vários temas de direito internacional e direitos humanos. Quem vai se aventurar, por exemplo, de ser amicus curiae na Corte Interamericana, o guia prático que é lido por todo mundo, que é usado por todo mundo, é o dele. Né? Então, vocês aproveitem esse lado da competição, de se conectarem com pessoas bacanas e de fazerem parte dessa comunidade. E mais uma vez, assim, todo mundo está aqui tem que se orgulhar, certo? Eu sei que queriam ambos os times estarem na final, a competição é assim. Mas, de verdade, a gente não faz elogio gratuito, nós ficamos muito impressionados. Então, equipe do Respondent, vocês devem se orgulhar pelo grande trabalho que vocês fizeram, certo? Então é isso. Obrigadão, um
Pessoal,
abraço para vocês.
obrigado, professor Henrique. Rápido, vamos tirar mais uma foto, porque deu um erro aqui. Então,
Opa,
em
tá,
3,
vamos lá.
Opa.
em 3, 2, 1. Perfeito. A todos os juízes convidados, muito obrigado pela participação em nome de todo o Instituto, a gente agradece. Ficamos bastante felizes, tenho certeza que os estudantes também gostaram da participação. E vou deixá-los ir agora para seus outros afazeres. Muito obrigado pela disponibilização de tempo. E peço que as equipes continuem aqui para poder passarmos aviso sobre a final e cerimônia de encerramento e premiação. Obrigado.
Um abraço a todos e a todas.
Tchau.
Tchau,
Tchau.
tchau.
Equipes que estão aqui, equipes que estão lá no YouTube, vamos lá. Então, como já ficou claro, as equipes que irão para a rodada final serão as equipes 2696 e a equipe 2644. Desse modo, a equipe que terá preferência de escolha será 2644. Vocês têm 5 minutos para enviar a escolha para o grupo do WhatsApp. E sobre a final, as regras você já sabe que é um pouco diferente, serão 30 minutos, tal qual até então, porém haverá um adicional de 15 minutos por equipe para que os juízes façam apenas perguntas para os oradores, podendo escolher ou não o orador e serão 15 minutos especificamente só para isso, não há fala dos oradores nesse momento. Logo em seguida, possivelmente às 8 horas, nós teremos a cerimônia de premiação. E a premiação envolve memoriais, melhores oradores e também as equipes campeã e vice-campeã. Então, todas as equipes podem estar nesse ranking ainda de oradores, memoriais e também definir campeão e vice-campeão. Então, pessoal, muito obrigado. Até mais tarde. Qualquer dúvida é só enviar lá pelo WhatsApp. Tchau, pessoal. Olá, Caroline. Tudo bem?
Oi, tudo sim, e você?
Tudo tranquilo. Já já faço a verificação da sua equipe. Sua outro colega já está para entrar, correto?
Isso, ela já vai entrar.